ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ?
What is that? Fresh matters, huh? We have given a date, no? No, we have given some date. Just check it out. Labor matter, fresh matters. Then it will come next week. Fresh for it. All fresh matters will be taken tomorrow. All fresh matters. Final hearing, what is that? What is it? Labor matter? Huh? Labor matter, huh? Second appeal, Thursday. Thursday, second appeal on Thursday. Second appeal on Thursdays. What is that? Your party in person. The party in person. Later, Monday. So what happens? Even if the court is not sitting, the memo would be taken by the other court. Yes, what is the urgency? Second appeal. How is MFA? We don't have the roster of MFA. Some before other bench, not before this bench. Thursday, Friday.
Number 3, page 4, 19 to 22, page 5, 23 to 29, page 6, 30 to 35, page 7, 39.
My lord, 40, my lord, serial number 40.
To appear for whom?
Mr. Anantram, his friends have requested for a week's time, my lord. They want to engage a new advocate. They've asked me to see.
I appear for the respondent.
To appear for the petitioner, Mr. Subramanian.
I'm sorry. For
T.S. Anantram, he is no more. So
Since
you
he passed
undertake
away,
to
my lord, his union friends have requested me to seek a time, week's time. Kindly give week's time for them to engage a new advocate.
So council on submits that T.S. Anantram is no more, and submits that the union has requested to seek an adjournment, and they are making necessary arrangement to engage another council. At request, this matter after 2 weeks.
Please, my lord. Obliged.
Wait for it.
serial number 55, my lord. I am for the petitioner. I request for a week's accommodation, my lord. I have been informed Madam Nandita Aldepur also.
Yes, at request of the petitioner council, this matter week after next.
Interim stay may kindly be extended. Interim stay may kindly be extended.
The order granted earlier is extended to the next date of hearing. Yes, week after next. 22 matter, right? 2022. Will they appear for? Have you informed the other side? When you inform the other side, they'll be waiting, right? You inform and then get back to the court. Yes. Correct. We have already completed. What is that one? Huh? What is mail photo? So why are you moving before this court? Yes. Preliminary hearing, huh? Yes. Correct.
Number 1, number 1, second one. Remove the attention lighting.
What is that impugned order now? What does it say? What does the impugned order say? That is regarding to consider your representation. Then what happened now? By impugned order, what has happened now?
ಸದರಿ ವಿದ್ಯುತ್ ಮಾರ್ಗದ ಅಡಿಯಲ್ಲಿ ನಾವು ಕೇಂದ್ರ ವಿದ್ಯುತ್ ಪ್ರಾಧಿಕಾರ
Yes, you take notice for the SCGP to accept notice for respondent number 1. Who appears for the transmission from corporation? Who is the counsel? Who is the standing counsel? H.V. Devraju is directed to accept notice for respondent number 2 to 5. Petitioner counsel to serve the petition papers on the learned counsel. Yes. Yes. SCGP to accept notice for respondent number 1.
Lord, I'll take notice for R3 minute.
Swarup. C. Swarup is directed to accept notice for respondent number 2 and 3. Petitioner
3.
counsel to
The
petition
3
paper.
alone, my lord. 1
When
and
do
2
you-
will be represented by government advocate.
1 and 2 na? 1 and 2 SCGP, 3 by Swarup. Petitioner counsel to serve the writ petition papers on the learned counsel appearing for respondent number 3. Yes.
Much obliged.
The week after next.
That's for the petitioners. Milord, this is a matter arising under the Provident Fund Act. Petitions filed in the year 2019 pursuant to Supreme Court direction to give revised enhanced pension based on certain formalities being complied with. Applications were made, and for more than 2 years, the department is sleeping over it. Every time they come to the court and say, we are sorting out, we are doing this, we are doing that, as though it is such a Herculean task. 7 only of the petitioners out of 26 now have been told that they would be given the revised pension. There are more than 300 employees, and
Yes.
in spite of
The
Supreme Court
higher
direction,
pension has to be given to the petitioner. Higher pension, huh?
this is a pension.
Is it necessary for them to apply, or you have to give them the higher pension?
Already applied. So, whoever has applied, that in that time,
Once they give an application, you have to do it immediately, right? That R.C. Gupta then.
there are 17.4 lakh applications. So they are in the process of.
When did they give their application?
2 years back, Pilot.
Then 2 years is not sufficient for you.
And
to
my
qualify.
writ petition itself is 4 years, 5 years old.
In
2 years prior to this, 23.
Not for the first 3 years, they went on saying we have filed a review petition. Then review petition was also settled, and the Honorable Supreme Court directed compliance with the order. Earlier order also they have not complied with. And every time they come to the court and say, give us time, kindly fix a deadline, my lords, for them to comply with it.
Yes,
Many
madam.
of them are 65, 66 years old.
See, now this is all settled, right? You have to just quantify and then.
Some of the people they have to, the employer has to publish.
See, whoever have given that, whoever have given the representation, whoever are entitled, you have to at least calculate and tell them that what is their entitlement. You don't even do it from 2009.
The demand has been sent to the employer,
See,
acceptance
how-
has not been received. Some of
Is it justified to make such a submission that after 2019, this is nearly after 4 years you're making the submission that it's still pending. Correct. When was the judgment? When was the judgment? So 22 to 24.
They have,
Yes.
July 23, they were permitted to take the action.
So as per the R.C. Gupta's case, right? This
Yes,
is
my
as-
lords.
As per the Supreme Court,
Which is the judgment of the apex court?
In 2000,
When was the order passed?
the judgment came, my lord, R.C. Gupta's judgment came in.
thereafter they were given time till.
What was the time?
In July 2023, they were permitted
So they have made an application.
October 2016, Lord R.C. Gupta's case, followed by another judgment of the Supreme Court, which was reported on 4th November 22.
Yes.
Now, two judgments are there. They have already complied with large number of people in Kerala. When it comes to Karnataka, they have developed cold feet just because the people are silent. That's not fair for them, my lord. We have been begging them virtually for our right.
The employers online in 31st May 2024, they have
So what was the deadline prescribed in the Sunil Kumar's case? What was the
in
deadline?
Sunil Kumar's case, they were permitted to make the application within 6 months.
Within 6 months.
Thereafter, that was extended because they had sought for time.
Correct.
And
When
that
was
has
the
been extended
deadline?
till now 11th June 2023, it was extended.
So 11th June was
But
3
11th
months.
July 2023,
So
the
le-
period was extended for the employees to make their online application.
So these petitioners have made their online application before 11th July
Yes, now
2023.
thereafter, now the employees have to process the applications for validation of the option, and that is till 31st May 2024. The employers have been granted time with
So
that.
31st May 2024, it's already lapsed now. We are in
Yes, so
we are in
the process-
September. Madam, we are in September 2024. It takes you nearly again 4 months after that to again wait. See, from 11 July 2023, the applications are pending consideration
Yes,
before
but
you.
there is a process
No,
for that.
correct. There is a process. You were given deadline till 31st May 2024, is it not?
No, deadline is for the employees to furnish the.
Correct. They have
validation
furnished.
of-
They have furnished you all the details before
No,
31st
in
May.
that some of the cases it's not done.
Which are the cases which have not been done by the employer?
No, remand, in the first case, the remand letter has been sent to the employer, acceptance is not from the member. Thereafter, and it is under process. The remand letter acceptance.
Under process, what does this mean? Under process, what does it mean? Does it mean that you have not received any information from the employer? Does that mean that under process it's from your side, right?
Yes.
Under process is from your side. So when will you complete this process? You give a streamline to this court as to when you will complete the
I
entire.
just,
Yes, pass over. Pass over the senior counsel. Mr. Isin Murthy, pass over.
Very well, my lord, very well.
You get instruction as to when you will. Ah. Which are the other matters? Which are 58 and 59, right? So we'll hear all these petitions together. Pass over. 230. Serial number 4 and 58 and 59. 230. Ah.
Be able to demonstrate that he was not known of all.
What happened now? Both are different persons. Huh? Have you filed your objections?
First beneficiary of reading is the
No, let him file his objections. Yeah, coming. State to file their statement of objection by next week. Is this matter on 20? 25th. Non-filing of wakalat. When will you? Dear drafter seeks time to file his wakalat. At request, a week's time is granted. Yes. Yes, Mr. Deepak. What is this non-compliance? Correct.
Waterman and executive that they have been made as accused specifically in the FIR at Alexa B. That was Malad.
Alexa B.
Yes, Malad. FIR they have been made as accused personally.
What are you challenging before this court now?
I'm seeking for a direction from R1 to R5 to compensate me for the sum of ₹50 lakhs for the disaster. Malad. The petitioner is a victim who died because of the negligence of responding 26.
No, but then that is by the you may have filed an FIR against these respondents, but you cannot make them a personal private party in this present proceeding. What you have to make is the institution, the authority.
So the report filed in the FIR, it was the disaster that occurred was due to the personal negligence of the respondents.
The personal negligence is something different. You cannot make them as a party in their individual capacity here. You correct the office objections. You petition a counsel to rectify the office objections by a week. You make it. Yes, Mr. Natraj Ballal. Huh? At request, a week's time is granted to do the needful. Yes. Yes, Mr. Srinivasan. To the LR application. Why? What is that objections to petitioner? They are not the legal heirs, according to you.
Still underground. The logics permitted in repeating applications by 5%. But kept the question of locus open.
Let us understand first. Now, what is the order under challenge? Objections they are filing.
I have asked for certain benefits because of the earlier orders of the High Court, under which I have asked for. I raised the dispute to a union, to an association. They have challenged, they said that association after the sugar company was closed, there is no more functioning, so dispute ಮಾಡಿದ್ರು. ಅದರಿಂದ I got some of them impleaded. Now the question is, once there is a court order impleading the second petitioner Venkatesh, and then he dies, the only natural thing for me to do is to bring the LR of Venkatesh on record. Now the question whether he is entitled to, she is entitled to or not is a larger question which the court can look into at the time of final disposal. Now the only question is, in view of Venkatesh's death, somebody should be there.
Yes, what is wrong? See one thing. It is for the limited purpose of prosecuting this petition. That would not create any right in their favor. Because the petitioners 2 to 6 were permitted to come on record. You raised an objection that you raised correct? And they were permitted to come. Now, if one of the parties dies during the pendency of the proceedings, what will be the consequence? Have you served the copy on the other side? You could have served him on that, right? Who will take the seat? We have to see now.
My only submission, the relief that the petitioners have sought for is for payment of alleged dues to alleged workers. I am disputing both the entitlement and their very identity.
No, that you can always dispute. That you can always dispute, right? Yes, sir.
Numerous persons, alleged workers. They filed in the name of a defunct union, despite knowing fully well We must become in the time of filing the writ. Okay, fine. We got hold of the document showing that we must know, we raised the objection. A previous coordinate which is not it's like, what do you mean? How do I learn? Take 5%, like the petition. So on that, your lordship would please follow the 5%. Question. Whether 5 persons can expose the cause of liability, plus whether that changes the nature of the petition, it becomes a conflict in this litigation. They are not saying give me my dues, they're saying give everybody their dues. If their case is give everybody their due, question of bringing the deadline doesn't come. Because it's fought on behalf of so many other people. If they're restricting their prayer to these 5 people, then yes, as my learned friend says, the other application means I will not even ask you. I have no voice to raise it. But if they are fighting it on behalf of so many other people, then it was an LR application. May not be maintaining my solution. That's not going into the merits. For us to fight, when a court order, they have to come on record. Now, when one dies, they have brought. It's open for the court finally to hold the release in the manner it requires. Ultimately, they have given a representation based on which we are also asking that the representation be considered, and they are the sugar company who represent, but they are fighting against the government. Whoever has to examine the thing, we have given a written representation, all the workers have a question of considering
Now,
whether.
in this petition, or rather before the labor court, what was your grievance? You are seeking prayer against, you are seeking for gratuity for all the workers.
What happened? They had discriminated between permanent workers and say these people.
Your petition would have been maintainable when it was by the union, because it was a cause in general.
Yes.
Now you have come on record as the 5 petitioners.
5 petitions.
You are not, you cannot argue or you cannot take a contention on behalf of the other workers now. Because you are.
That matter may not, your lordship may consider at the end. When the matter
Ultimately, what would happen? See, your cause before the labor court was totally different.
before the labor court, he had come directly to the court to the simple. There is a court, but the court there was a previous order of this court which says that there cannot be, you cannot discriminate stating that they are seasonal workers. There is nobody called as seasonal worker. I have produced those orders. It went up to the Supreme Court. And the courts have said that in this industry, you cannot call them as seasonal workers, and you cannot discriminate. You cannot pay 7 days gratuity instead of 15 days gratuity. All that is noise later. The question of the technicality involved in the courts approaching, even the interview kept open. I'm not telling. Now, for the present, there are only 5 workers who have been come on record. What is the maintainability of the petition based on those 5 workers? It is open for him to argue before this court. At this stage, he is not making a solution. So, at this stage, it's only one issue. Venkatesh passed away, my lord. It was my duty. If the court says he is to be brought on record, the wife is to be brought, whatever benefits she ultimately the court may find that he is entitled to. Only that keeping the open will be allowed. And after that, the court may hear it on, including the maintainability, and he may convince the court.
Having permitted them to come on record, this would not be necessary. That application should have been heard on mail. No, that application allowing.
Once they are allowed to come on record, already 5% were already allowed. But he starts.
No, see, the limited purpose again only to the extent of disposing the cause. Because if the application, the main application would have been heard along with the main, that would have been.
Yes. So having allowed that.
Allowed it. Now we cannot say that these LRs are not permitted. That would not. That would be against the principles. Yes. Which is that I. Order on I number 1 of 2024.
The second petitioner passed away. He is coming on record.
Application is fine. by the petitioners to permit the wife of deceased petitioner number 2 to come on record. Petitioner number 2 died on 14/2/2022, leaving behind his 2 children and the petitioner and the proposed petitioner. Why are you not including the other 2 children then?
Even in this matter, what they have said, she ultimately takes it as a trustee for the entire class. That is all. She represents.
Objections are filed.
Right on 14/2/2024 or
14/2/2024. So the application
14/2/24.
application and affidavit is shown by the wife of deceased petitioner number 2 to come on record. And to come on record and to and justify the costs made by the petitioners, the petition. Objections are filed to the application by the respondent number 2. Inter alia contending stating that the respondent had filed objections to the application I number 1 of 2023 to include the alleged 5 workers as petitioners in this petition. And the application was allowed and recorded by this court only for the limited purpose. And as such, it contend that the pleading petitioners have pleading petitioners had no local standing, and still it is open. Comma, the question of permitting the legal representative is It's contended that the deceased petitioner number 2, whether entitled his locus to prosecute this petition and the maintainability of the petition itself are all still open questions. And the proposed legal representative of the petitioner number 2 is neither a necessary nor a proper party. And the proper party and sought to dismiss the application. This court-wide order dated 14/2/2024 allowed I number 1 of 2023 filed by the proposed petitioners 2 to 6 to include them as they were the former workers of respondent number 2 sugar factory. On hearing the application, the application on hearing, I number 1 of 2023 was allowed to the limited extent of exposing their costs. And the petitioner 1 to 5 were held to be 2 to 5 or 1 to 5? 2 to 6, 2 to 6 were permitted to be included in the proceedings. Now, by way of this application, I number 1 of 2024, to bring on record the legal head of petitioner number 2, this court deems it appropriate to allow the application as she petition the pleading petitioner is to the is coming on record to the extent of petitioner number 2, and to the limited extent of exposing their cause. So accordingly, I-1 of 2024 is allowed. Petitioner is permitted to amend the cause title and file amended cause title within a week. Yes, Mr. Lakshman Rao, what is this, madam?
Lakshman Rao.
Yes, Mr. Somshik,
Yes, ma'am. Appear for the.
they have filed an application. What is this application for?
This or the deposit held in the school Petition, it's for 13 lakhs.
Is that IA filed by you?
In 2024.
Did you make an application before the labor court? Did you make an application before the court below? Any application was made by you?
So,
Ah,
I did I
no, against what order you are before this court?
No, we are before this court, my lord, challenging the award.
What is that
Where he was
award?
reinstated with 50% back wages.
50% back wages.
Yes, ma'am. Reinstated with 50% back wages.
Ah,
We were paying 17B, but on 18/4/2019, Jet Airways closed the operations. So therefore, we stopped with the payment of 17B. We had deposited about 13 lakhs. So this honorable court, by an order dated, which is enclosed to this IM before, 17/8/2020, order to pay interest till June 2019, where the operations were closed. Therefore, to pay interest on that. Now he has made an application for the subsequent period, saying that the interest accrued thereafter should be paid to him. Now the Jet Airways was before the NCLT. I have filed the detailed objections.
They filed objections to this IA. Have you filed objections to I-1?
Yes, ma'am. 270 pages I have filed. Because it's from Bombay, they make it 270 pages they have sent me. I have filed the entire thing.
Is now you are claiming interest for what period now you're seeking?
October
What was the order of this court?
This case here, I just made
What was that order? This is I-1 of 2019. This order was on I number 1 of 2019.
This I given made a written argument that I will also consider. I have given all the required law of the land to be considered for grant of this justification.
So this court held that you are entitled for interest from May 2017 to June 2020 because the amount is deposited in the, on 20th June 2019. On that contest, this court said you, the petitioners to pay the interest amount. Now, what is your grievance now?
Now, after that, that was the period which the interest paid. Now, after that, the interest again has come on this particular 13
No,
lakhs.
that is not the criteria. They cannot go on paying the interest. This amount is already deposited before
I
this
appreciate
court.
your addition, but there's a delay.
Correct. This order, there is a specific order of this court that you are entitled for interest from May 2017 to June 2019. That is the
That's
date.
the old
That is the date on which they had deposited that amount.
shit.
After that, is there any deposit or is there any delay
It
payment?
has been extended and the interest has been earned on this particular.
Correct. That has already been accruing in your deposit amount.
I appreciate your addition.
No, but then how can-
With this, there is delay of held by the petitioner. Every time they keep adjournment, even the withdrawal memo has taken 4 months. On this basis,
No, if it, Mr. Somshankar, whatever
Yes.
is accrued, can we not disperse it to the?
No, my
petitioner?
lord, that's what the objection, because NCLT now has approved the demerger closure of this JCLT and a joint owner have taken it over. Therefore, whatever the claim they wanted, he should have made. In fact, it was brought to the notice of his. He made a claim for what's only 63,000. He should have made the claim for the entire from his dismissal till the date of closure. He should have made all his claims. Now the authorized representative who has been representing NCLT, the Jet Airways, he says that he claimed only. You let me, my statement of objections may kindly be taken, my lord.
One thing, Mr. Somshankar,
My lord.
earlier IA-1 of 2019 was filed by him,
Yes, ma'am.
and which an order has been passed wherein the interest amount for the delay period, that is.
No, you let me
2000
kindly see para 2 of that order, my lord. That is very important. Para 2 and 3.
Yes.
Para 2, my lord. The
Yes, read.
learned counsel for the petition vehemently contended the respondent party is not entitled to the relief sought for in aforesaid IA. In view of the order passed under section 14 of the Insolvency and Bankruptcy Code 2016 on 26 by the jurisdictional court tribunal, that is NCLT. Next parameter. Pursuant to the interim direction, petitioner is stated to have deposited 13 lakhs. That I deposited in 2007, my lord. 24/2017, I had deposited 13 lakhs. Whereas the order passed under section 14 of the Insolvency and the Bankruptcy Code is on 26/6/2019. The present IA is present 26. Therefore, 26. After 26/10, there was a moratorium. Therefore, he could not make any claim subsequent to this date. Therefore, this honorable court, from 2017, the date of deposit till 2019, ordered for payment. Now he is asking for subsequent payment. For subsequent payment, what the authorized representative for the Jet Airways says, my lord, I have filed a detailed objections. He should have made all the claim before the NCLT.
Where is your objection?
My lord, it runs to about 270 pages, my lord.
Objections today. When did you file your objection?
That is on Friday, my lord, 13th. I served the copy on.
If the office or this objections are not available here, we'll ask the registry to put up.
My lord, in the meantime,
File your objections.
my lord, one submission, my lord. On the judgment I have produced, my lord, in this objection statement, Ganesham Prasad, the quota number 11 has already passed an order that any claim which is not made before NCLT get extinguished. That order is dictated on 11th, my lord, by the quota number 11, but it is not. Therefore, a week's time is granted. I think I will get that order also, where it clearly says that if the claim is not made before the NCLT, his right gets extinguished. He made only for 63,441. NCLT has accepted as of 56,000.
That is on merits of the matter, right? Then we have to merits of the matter, right? Whether he has made.
Here also, my lord, see, I have filed a detailed objection sent from Bombay. They say even the 13 lakhs should go to Jet Airways, and then the writ petition has to be allowed or closed, and only all his claims should be before the NCLT.
Then we will hear this matter on merit itself.
In that case, my humble submission, I think we will file a hearing because this particular case, NCLT is judgment is there. 6108, they were supposed to pay me the salary. On that basis, I'm going to they will not produce Form B. In this whole objection, they will not produce Form B. And 280 pages, I just see this particular whole procedure, 280 pages, goes null and void because they themselves before the Supreme Court upload the whole proceedings.
Will you file that document along with the memo? We will hear this matter on merits itself.
Have a look at it. 280 pages goes null and void because they themselves are told before the Supreme Court that the whole proceeding is a joke. Have a look at it. Remove page nandu bandu very move page ಇದೆ. Idrallu I can argue. Every page I can argue. And the, Article 227, the High Court has got the superior for all the court, and NCLT is a tribunal as per the Companies Act 407. The Companies Act and the IPC code clearly states that there is a consolidation fund where I can be given the salary also.
Produce this along with the memo.
This
This matter.
short date may be given.
25th or 26th minute because I will get that order also from court number 11.
Secondary hearing we group along with I number 1 of 2024.
25th minute or
25th.
much okay.
Good, man.
Mr. Muralidhar.
Before the final order was passed in the said dispute, order to extend key was passed. With my lordship granted in page 57. And to see the operative portion of the order. With my lordship granted in page 63.
What is this disciplinary?
The order on domestic inquiry is held in favor of the defendant. That is, as not fair and wrong. And followed by another order at annexed K in page 74. 74. The lords would get the operative portion of the order.
What is this order?
This is granting him interest offers in 3,000 per month. And given from 6/2014. This is the order. I challenge both orders before this honorable court in WP number 3270 of 2017.
Where is the writ petition order? Where is the writ petition order?
I along with my Page 2 of the order. In page 2 of the order, I have done a fourth order. The Lord should get it.
Yes.
And during the intention of the order connection here therefore, I have filed this and the Lord's on the last date of hearing asked, what is the date of his retirement? 30th September 2008 is the date of retirement. Now the amendment sought is, since I have, since when I filed this petition was still pending, I have sought amendment of credits and prayer to challenge these two orders also. The orders on D as well as the orders passed on. That's all.
Seven.
2023 to 27 to 2023. There is a regarding delay of 19 months. So there is no reason for coming in application for the delay process. And more that they themselves are the last one before the honorable legislative tribunal on the 35 to that amount was also not paid. And even before this amount go to Adana, on 35 2018, honorable court is also directed the petitioner to pay the current wages to the respondent. Only 61,677 was paid. No memo of calculation is filed by the petitioner. Some of the court directed the petitioner to file the memo of calculation.
That is on merits. That is on merits, right? That is on merits of this petition. As to what he has not done and.
There is a direction in 27 months to file a memo of statement.
No, we
And
will.
also, if not to present the general manager, neither the made payment, not the file the memo of calculation. And the general manager is also not present to this transaction. Interim relief is not complained, and this decision is not identified, and the decision is not outcome. Their intention is only to harass the respondent.
See, interim order is interim order of granting compensation or granting an interim. No, interim relief is for the temporary period. During that period, you have to pay that amount.
I can never also, in compliance of the orders of the court.
There is no.
What happens, Aiza has some
Which is that, where is the memo filed by you?
along with the particulars of the.
No date really. You can understand you're challenging the order of the domestic inquiry. But where is the question of challenging the order of interim relief being granted?
Is already paid.
Correct. Then if you are paid, why are you challenging that order of interim?
Only incorporating that in my treaties.
Right. Where is the question of challenging or making it as a prayer in your writ petition? You have challenged that interim relief also. See,
Yes.
once a final order has been passed, interim relief merges. Then you have to pay whatever has been directed by the. So according to you, if it is paid, where is the question of challenging that order of interim relief?
I can be committed to challenge the order sum.
Only the.
Yes.
They will not challenge the interim relief.
But in the meantime, I paid it.
No, we will say that you are not pressing that IA. Pressing the IA insofar as the relief, the interim relief is concerned, as you say that it is already been paid.
Yes. Paid. No. In my prayer also. All that I am saying.
No, you cannot challenge that interim relief prayer. You can only restrict your prayer to the domestic inquiry, to the orders passed on that IA. Yes. Limit counsel. Limit counsel for the petitioner does not press the amendment application insofar as challenge to the order dated 35/2017 at annexure K. He's not claiming, he's not pressing that the such submission is recorded. Next one. Order on I number 1 of 2023. Application is filed by the petitioner seeking to amend seeking permission to amend the memorandum of the petition with the following proposed amendments. Page number 3, I number. The objections are filed by the respondent to the IA. You have filed objections, right? Inter alia contending that objections are filed. Third, the learned counsel on both sides. Learned counsel for the petitioner submits that the petitioner had filed writ petition 32600 of 2017, challenging the orders dated 23/2015 and on the fairness of domestic inquiry, and the order dated 35/2017, awarding interim relief to the respondent, before this court. The petition 32660 was filed, challenging the order dated 23/2015 and on and 35/2017 regarding the interim relief passed by the Central Government Industrial Tribunal cum Labour Court, Bangalore, in ID number 2 of 2017. And during the pendency of the above mentioned petition, the CGIT, practically CGIT has passed the final order, and the petitioner having challenged the final order dated 15/9/2017 in the present petition. Liberty was sought in WP 2600 of 2017 to urge all the contentions in the present petition, the instant petition. This court has granted liberty to the petitioner to raise all the contentions in the present petition. Accordingly, the present application is then it's something for the respondent submits that the order granting liberty to the petitioner was passed in the year 2021, and the application and the present application is filed after the lapse of 19 months, and there is an unexplained delay in filing the application, and the application is filed only to protract the proceedings. I sought for dismissal of I number 1 of I1 of petition. This court, in the writ petition filed by the petitioner assailing the order passed on the fairness of domestic inquiry and the interim relief, had granted liberty to the petitioner to urge all his contentions in the instant petition. The amendment sought by the petitioner is in light of the liberty granted by this court, and in light of the settled proposition of law that the interim orders passed by the Labour Court cannot be challenged at every stage, and the petitioner has made out a ground to allow the application insofar as the fairness of domestic inquiry is concerned. Accordingly, the I number 1 of 2023 is allowed in part. The petitioner is permitted to amend the writ petition, incorporating the amendments of insofar as disciplinary inquiry, fairness of disciplinary inquiry is concerned. On payment of cost of rupees, pay some amount for that, of rupees 5,000 payable to the respondent by next date of hearing, and file an acknowledgement to that. Next, learned counsel for the petitioner has filed memo in compliance of the order passed by this court dated 27/1/2023. The learned counsel for the respondent submits that she is not in receipt of the memo Petitioner counsel to serve the memo on the learned counsel. Petitioner to amend the cost, right? Amend the writ petition. Yeah. Correct. Amend then next para, petitioner to amend the writ petition and find amended cost of writ petition within a period of 1 week. Yes, Mr. Narayan Swami.
Appear for the respondent.
What is this application for?
Gradually, that's some minutes because it's a case of refusal of employment. Dependency of the matter, they have filed a memo, they are ready to take them back to duty. Thereafter, they have reported. From the refusal date to reporting date, they are asking for the wages. And one more thing, minutes, thereafter, after 6 months, they have closed the unit at Bangalore. And all these employees were transferred to Tumkur. That dispute is also pending for adjudication.
Now you are already been reinstated.
Yes.
Yes. So that reinstatement is a benefit to you now.
Only that pending, but up to that day, I mandate for.
From what time? What time to what time?
That's
What is the
period is from 18/3/2014 to 21/6/2016 minutes. 21/6/2016.
Yes. You
That
have
is the date on which they have filed the memo before the labor court. In
That-
response to that letter on 22/6/2016, I have reported for duty.
so you are working now with the establishment.
Yes. On 2/1/2017, all these workers were transferred to Tumkur.
And now you are not working in
Not
the
working, they have not reported that matter.
that is again a different discipline. Different misconduct.
That's a pending matter before the labor court. Under these circumstances, Milan,
So you are not working, you don't want to work in the transferred wherever you were
that's
transferred.
too bad because the
And what is the establishment?
circumstances was reported because my family and children and my wife was and their wives are working here. He can't maintain two families either.
Two families are, he is married there.
ಸಂಸಾರ ಜೀವನ ಮಾಡಕ್ಕೆ
ಎಲ್ಲ ಕಡೆ ಹಂಗೆ whenever ಅಲ್ಲ
ಎರಡೆರಡು ಮನೆ ಇಟ್ಕೊಂಡು ಮಾಡಕ್ ಆಗಲ್ಲ ಯಾಕಂದ್ರೆ
added money ಅಲ್ಲ separate house ಅಂತ is residing separately living in added money ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಬಿಡುತ್ತೆ.
ಅದರಿಂದ ಐ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲರ್ನೆಡ್ ಫ್ರೆಂಡ್ ಆ ಸ್ಟ್ಯಾಟ್ಯೂಟರಿ ಡ್ಯೂಸ್ ಏನಿದೆ ಕೊಟ್ರೆ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದೆ. ಅಲ್ಲಿ
What is your amount you're claiming? Give one amount to them so that they'll be able. ಇಷ್ಟೇ ಬೇಕು ಅಂದ್ರೆ that is very difficult.
ನಾನು ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ. ಈ 2014 to 16 ಗೆ I leave to the management to decide what is the amount they want. But up to the date of 16, I mandate for gratuity.
You have worked.
Yes.
No, in light of reinstatement.
Like what I said.
Light of reinstatement order and that not being challenged by the respondent. Alva?
They themselves have filed a memo.
They have said that they will.
They are ready to accept.
What is the order now? They are challenging.
Now, reference was rejected. Refusal of employment to reference ಬಂದಿದ್ದು ಆ reference ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. During pendency they were taken back.
That was claim was rejected. Your reference was rejected.
Reference refusal ಇಲ್ಲ ಅಂತ rejected.
But then there was a reinstatement order by the.
Yes. By the same court.
Yes,
ಅದಕ್ಕೆ ಈ
Mr.
peculiar circumstances ಅಲ್ಲಿ
Yes, Mr. Somshekhar, now that.
management of consideration
Though there is a reference being rejected by the labor court, but fact remains that you had reinstated him from 22/6/2016. Alva. Mr. Somshekhar.
Yes, madam. Yes, ma'am. But then on 2/1/2017, we transferred all these persons.
Now that
because
is a separate cause of action where you are already giving them.
No, they have challenged it. It is pending before the tribunal.
Ade,
They have
adu
challenged. They have challenged the transfer. That dispute is pending in reference number 92 of 2017 before Industrial Tribunal. That's why I told
Once,
Narayana once
see.
you have challenged the transfer order, how can we say that you should either should go report for duty or the tribunal should come to the conclusion my transfer is wrong?
That is after 2017. Now the
Yes.
dispute is between 2014 to 2016.
That is rejected by the court because it says that there was no refusal of work.
Correct. That is on merits. Now, merits. That is on merits, Mr.
Yes.
Somsekhar.
Yes, ma'am.
Now you had already thought of reinstating him into
We
service.
reinstated because our factory was in Whitefield. We reinstated, they were working. Then on 2017, I transferred all the 30 employees to that place. All the 22 have gone and reported. The 7 people have not gone. They have challenged the transfer. They have challenged the transfer.
Family maintain ಮಾಡಬೇಕು ಅವ್ರಿಗೆ ಆಗಲ್ಲ. ಎರಡು ಫ್ಯಾಮಿಲಿ ಮೇಂಟೈನ್ ಮಾಡಬೇಕು
ಈ ಫ್ಯಾಮಿಲಿ ಮೇಂಟೈನ್ ಮಾಡಬೇಕಾದ್ರೆ ನಾನು ಇದ್ರೆ ಅಲ್ಲೊಂದು ಮನೆ ಮಾಡ್ಕೊಂಡು
ಎಷ್ಟೋ ಜನ ದೇ ಟ್ರಾವೆಲ್ ಔಟ್ಸೈಡ್ ಕಂಟ್ರಿ ಹೋಗ್ತಾರೆ ಅಲ್ಲಿ ಇರ್ತಾರೆ ಮತ್ತೆ ಕೆಲಸ ಮಾಡ್ಬೇಕಾದವರು ಎಲ್ಲೂ ಮಾಡ್ತಾರೆ
ಡೆಫಿನೆಟ್ ಆಗಿ ಹೋಗೋದು
ನೀವು ಎಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಸ್ವಲ್ಪ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಇಫ್ ಯು ವರ್ ಇನ್ ಗುಡ್ ಟರ್ಮ್ಸ್ ಎವ್ರಿಥಿಂಗ್ ವುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಸೆಟಲ್ಡ್. Now the management also. ನೀವು ಒಂದು ಫಿಗರ್ ಹೇಳಿ, we will talk to Mr. Somsekhar. Once you give a figure, it will give. ಎಷ್ಟು ಬರುತ್ತೆ? Mr. Somsekhar.
Yes, madam.
Ask the concerned officer to be present before the court. Concerned, who is he?
Dr. Anju Leela Ramani, Chief Operating Officer. She has written a letter to me saying that they should come and work when all others are working. Why should they don't want to come and work? And
won't you refuse them work? Refuse them now. 2017, they are not coming. So
yes,
for you, it's a good ground to dismiss them from service. That is something. Now from 14
no,
to
they are the transfer matter that is pending. Otherwise, we would have
you look at your workmen. Alliyu hogalla, illiyu baralla. Transfer ಮಾಡಿದ್ಮೇಲೆ ಇಲ್ಲ ಹೋಗಲ್ಲ ಅಂದ್ರೆ
the factory close ಮಾಡ್ಬಿಟ್ಟಿದೆ Whitefield.
It's only now some humanitarian grounds they would be giving you something. ಇದೇ ಬೇಕು ಅದ ಬೇಕು ಅಂತ ಅಲ್ಲ. ಅಲ್ಲ correct. In the event this court holds that the termination is proper, you would not be entitled for ಎಷ್ಟು ಇದೆ gratuity? ಅಲ್ಲ 14 to 16 ಬರಲ್ಲ ನಿಮ್ಗೆ. 14 to 16 ಹೆಂಗ್ ಬರುತ್ತೆ? That is the date of refusal ಅಲ್ವಾ? ಹೆಂಗ್ ಬರುತ್ತೆ? ಅಲ್ಲ ಮೆಮೊ ಎದಕ್ಕೆ ಹಾಕಿದರೆ that is ಅದು ಯಾವಾಗ ಅಂದ್ರೆ you have been reinstated on 22/6/2016. Your gratuity amount you are claiming from March 2014 to 6. ಅದು ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ. From 22/6/2016 you will get. For not working period. ಅಲ್ಲ if you have worked we will grant you. ಅಲ್ಲ see in the event correct Mr. Narayan Swamy, if the court holds that the termination is just and proper, where is the entitlement of gratuity to you? ಅಲ್ಲ ಹೇಳ್ತೀನಿ question ಆಯ್ತು. If this court holds, so whether you are entitled it is 50-50. Who is she? We'll ask her to be present before the court, Mr. Somsekhar.
Dr. Anju Leela Ramani, Chief Operating Officer.
We'll say the Chief Operating Officer to be present before the court. Okay. Learned counsel for the petitioner submits that there is a possibility of settlement as the petitioner is entitled for the benefits from 2014 to 2016, 21/6/2016. From 18/3/2014 to 21/6/2016. Statutory
benefits such as gratuity and other things.
Statutory benefits such as gratuity
and other things.
Other things ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Consent, what is her? Who is she?
Chief Operating Officer.
Chief Operating Officer to be present before the court by the next date of hearing. Is this matter on 23rd? 23rd, present Idivra.
Yes, ma'am.
Yes, Mr. Gautam Ragna.
Fear for the respondent, my lords.
Is there any
The lords
possibility?
had directed us to not able to hear the other side, my lord. Sorry, my lords.
You speak little loud.
All I is whether they're willing to give me a relieving letter, point number one, and whatever needs to
What, yes, on the last occasion, you mentioned that you are being re-employed. If you're giving him, he is inclined, he says that he wants a relieving letter. How much is your entitlement?
My lords, your lordship had directed us to calculate the amount, my lords, from the date of termination till her employment in another company.
That is, what is that? How much is the amount?
My lords, after deduction of the interim relief of 3,75,000 that is being paid and the 60 days salary that was paid to her during notice period, the amount comes up to 4,29,451, my lords.
Yes. We have filed a memo to that effect?
My lords, I have not filed a memo, my lords. I'll file a memo, my lords.
Yes, you file a memo.
Please, my lord.
then I shall place a memo on the document.
Is this matter on 25th? 25th. By then you file the memo, madam.
Please, my lords. Much obliged.
And his apprehension, or rather his contention is that you should relieve him or issue a relieving letter.
My lords, the question of relieving letter does not arise. She is already gainfully employed elsewhere, my lords, and it's a case of
That's
termination.
from 2009, from before the date when she was employed in another establishment. Why don't you issue her relieving letter that she is relieved from service? So does that relieving of service give you entitlement of other benefits?
What happens is, if there is no relieving letter, a background verification call goes, and they have blacklisted her, that becomes a problem. That being reason, if a relieving letter is issued, a quietus could be put to the entire litigation.
See, then you should not come and say that you are entitled for other benefits in light of the
Yes,
relief.
my lords.
All that I am seeking is that
So
from
that
the
you
date
should
I was
approach.
terminated,
No, you should approach the management, keep them in good books, so that they will be giving you a relieving letter. Yes.
Much obliged.
Senior counsel pass over this question, pass over in the afternoon. Senior counsel in the afternoon. Is Mr. Natsimhan? No, they are not ready to accept the 2 guntas of land. You may be ready to give 2 guntas of land. 21 ekare ಬರಬೇಕು ಅವ್ರಿಗೆ guntas. How much guntas you are entitled to? What is your name, Mr. Pass? We waited. This court waited for you. And you did not appear. Now you cannot tell this court that he should appear before this court. He is not here now. No, your colleague said he is held up in other court hall. You should have made an endeavor to come to the court. This court was waiting for you. We expect this court to wait for your advocate. And when a serious matter was going on, you did not even make an effort to come to the court and submit. Is it not? A lady was waiting here.
My humble submission, Your Honor, my
No, we don't know. Otherwise, she is entitled for 21 guntas.
settled this matter anywhere, but house are 2 plus of land has to be.
We'll pass over, let him see, let us see, pass over, after he comes here.
Otherwise, the matter will.
Oh, no, we are not going to adjourn, we are not, we are not going to adjourn it until the quitus is made to this, litigation.
Please, please.
Pass over.
Seven.
Further hearing, then. What is that name?
The issue was made that the respondent is. You are also directed that. Then it should be made with the member.
So the legal representatives, so they don't know. Then we don't know whether they are dead or no. Alva, adike Lakshman Rao conveniently doesn't come to the court. What is the misconduct?
I think the initial name, which can remind it.
Yes.
After moving an advisor, business would serve. The second order. The petition is the law. The awarding is cost. The proceeding evidence for consideration fresh. Open the material or record and pass an award on the merits of the.
Why was it remanded?
Because the case was not decided on merits. So therefore, there was a direct because the domestic inquiry had to be fair and proper. Therefore, the matter was decided only on the basis of. Kindly come to the award of the lady for page 26, page 26. The final one, page 23. What is the reason of the original document period? So making people domestic inquiry by both the parties. It is specifically under the evidence of the side of the marriage was very much open and believable with respect to the incident of manhandling the co-manager and also abusing the observer. On the contrary, the marriage counselor a party advocate tried to bring before the court for contradictions in the evidence of the sentence inquiry officer. Subsequently, the connection were only two paragraphs of this commission. Our connection and and hence the so-called contradictions cannot be considered. Whatever is necessary before the inquiry, this alone should be reviewed on the aspect of purpose of finding. And in that context, if the evidence of the management with which the inquiry officer is scanned, then it clearly goes to show that they brought true version. The last paragraph, paragraph 25. On the other hand, I have to observe here that there is nothing by way of cross-examination to the management witness for the work of the inquiry, so as to doubt the veracity or not to say, because the workman is not effectively protected his case, that cannot be a ground for the court. Coming to inquiry of only to persuade the application.
Domestic inquiry was held not to be fair and proper.
That's the reason it was remanded. Because what happened after the inquiry went on was held to be fair and proper. For reasons best known to the public, they also made evidence. And there was contradiction. Therefore, we approached this sort of court said restrict yourself to the evidence read before the inquiry officer. no other material should be examined because of the fact that the domestic inquiry was failed. Therefore, my lord, the court comes to the conclusion. And we come to paragraph 27 in past on 84 occasions.
84.
Paragraph 27. Page 28. On the contrary, it is very much evident from the cross-examination by the management it has very serious conduct of 84 occasions and management significantly improved lesser punishment. In the second cause of this, the management has made a reference to the past report not yet taken and the ground to the proposed punishment and it is evident that the prescribed not applied to the effect. The court comes after noting almost without the court comes to that paragraph 36 attains the age of superannuation. Therefore, it is one of the sole grounds which clearly circumstances do not interferes.
When was the order of dismissal passed? 2007.
20
Yeah, the articles of charges were issued only on 3/7/2000.
Articles of charge was on 8/6/19.
2007 ಅಂತ ಬರುತ್ತೆ your
Sorry, my lord. 97, my lord. 97 my lord, is the issue of charge sheet. He replies, my lord, to the charge sheet in 98. And the dismissal order is equal to October. Once, my lord, the charge is certificate and whatever is entitled to 3/20/99 has been paid. Corporation except for the production of fake certificate, in all other cases, the terminal benefit which is settled will be later. So therefore, what having regard to the fact that the charge is certificate interference with the order of
ಕಡೆ memo ಇಲ್ಲ, you don't know whether he has died. So we will, whom will contact? The dead person. No? Where are the alas? You should have done all this. No, my death certificate also. No, he's not dead. No, is he dead? When did he die? When did he die? Ade hedi. We will pass orders then if you're not aware as to when he has died. We have to think he's alive. Alva, you have got any information about his death, madam? No. No information from you. Yes, Mr. See, at least so many days have passed. You should have at least filed a death certificate. Are you sure he's dead? Huh? Yes, Sandra Henge. How are you sure that he's dead? Who told you? Huh? But your counterpart. Huh? What did he say? He's dead. Then what happened after that? There must be something on record. You will say that you have no information about the death of the corporation. Assailing the legality and correctness of the order passed in ID number 84 of 1989, dated 30th April 2012, by the Municipal Labour Court, Bangalore, therein referred to as Labour Court for Fraud, directing the corporation whereby the petition filed under section 10(4)(a) of the Industrial Dispute Act 1947, ID Act for short, was allowed in part by invoking section 11A of the ID Act, substituting the order of termination from service by virtue of deemed continuance in service, which entitles him for pensionary benefits as the retirement by superannuation is due on 36/2012. If continued in service. And next, assailing the WP 1955775 of 2013 is preferred by the corporation. Next, and WP 14658 of 2015 is preferred by the workman, assailing the legality and correctness of the order. And continue in service and high color. Back wages and consequential benefits, except for terminal benefits, are denied. Next slide. The responding was appointed as a conductor in the petitioner corporation. On allegation of certain charges, articles of charges were issued. Inquiry was conducted. The inquiry report was submitted, holding that the articles of charges were paid. Among the disciplinary authority, by considering the report and the material placed, dismissed the respondent and workman from service. Workman was dismissed from service. Reinstatement was filed under section 10(4)A of the ID Act. The domestic inquiry, on the issue of domestic inquiry, the Labour Court held that the domestic inquiry conducted by the corporation is fair and proper. And in the first instance, had dismissed the claim statement. Challenging the award passed by the Labour Court, the petition K1431 of 2005 was filed by the workman, and the same was allowed, and matter was remitted back to the Labour Court for further consideration. The Labour Court on remand decided the case afresh and again dismissed the claim petition. The WP was filed. Writ petition 21127 of 2010 was preferred by the workman, and the matter was again remanded back to the Labour Court for fresh consideration. On remand, the Labour Court has now substituted the order of dismissal to one of order of termination by directing payment of terminal benefits. Both the learned counsel appearing for the petitioner and the learned counsel appearing for the respondent workman. So the learned counsel for the respondent on so date on 12/1/2024 made a submission that the workman is no more and sought time to file details of the legal representation. Until today, no materials have been placed by the respondent to indicate that the workman is no more. And then learned counsel for the respondent is unable to substantiate about the death of the respondent. In the said circumstances, the matter is heard on merits. Articles of charges was issued to the workman on 3/7/1999. 1997, sorry. 1997.
otherwise the dates are correct. The second one, as you have said, the respondent replied to the articles of charge, except that the entire dates are correct.
Articles of charges on particular, first again. Having not satisfied with the reply submitted by the workman, inquiry was conducted. Articles of charges dated 1997 were issued as under inverted comma number on 16/1/1997 at about 8 a.m. along with Sri Mahi Manna, you get it at para number 1 of the petition papers of WP 19775 of 2013. In articles of question, threatened of dire consequences. Of money. The disciplinary authority accepted the findings of the inquiry officer and dismissed the workman from service by order dated 20/1999. Claim statement was preferred under section 10(4)(e) of the IDNR. The workman had approached this court on several occasions against the dismissal of this claim petition, and the matter stood remanded to the Labour Court for fresh consideration. The fairness of domestic inquiry conducted by the corporation was held to be fair and proper, and what remained before the Labour Court was to appreciate the evidence left before the inquiry officer in support of the charges. The Labour Court, while appreciating the evidence on record, has held that the charges are fair. And once the charges have been held and upheld by the Labour Court, the Labour Court could not have interfered with the order of punishment on the ground that it causes hardships to the dependents of the employer. What had to be considered by the Labour Court was whether there was victimization and whether the order of punishment was disproportionate with reference to the charges leveled against the workman. The Labour Court, having noticed that the workman had been guilty of serious charges of misbehavior, the interference of the order of punishment imposed by the Labour Court by the inquiry officer for the proved act of misconduct is not sustainable, is unsustainable. The Labour Court failed to consider that the workman was involved in 84 past misconduct, and the same was established before the Labour Court. The Labour Court has given a misplaced sympathy to the workman by holding that order of termination has to be replaced. Order of dismissal has to be replaced by order of termination and by directing payment of termination benefits. The granting of benefits to a workman who has been proved of misconduct is awarding bonus to the workman for his misconduct. The charge leveled against the workman is misbehavior to the superior officer, manhandling, and abusing in filthy language. And the such misconduct by the workman is of a grave nature and could not have been lightly taken by the labor court. The past misconduct is not of one charge, but 84 charges, 84 misconducts. The labor court's order warrants interference by this court. And this court passed the following order. The writ petition WP 19775 of 2013 is allowed. WP 14658 of 2015 is dismissed. The impugned order passed by the labor court is set aside. Mr. Prabhakar, please, email from Mr. Shekhar, what is this? 33 C2. Yes, Mr. Subramanian.
Your lordship had suggested to settle this matter on the last occasion.
Yes.
Yes, in principle, we are agreeable to settle the matter. I only request your lordship to kindly see the operative portion of the award, which is at
absence, huh?
yes,
Train.
That is 33 C2 order, my lord. On the last occasion, your lordship wanted me to settle the matter. We will definitely settle the matter, my lord. Kindly come to page 57. That is the operative portion of the order.
57. Yes.
I have been directed to pay 41,900 rupees with the interest at the rate of 6% per annum. My lord, I am ready to pay 41,900, my lord. I request my learned friend to forgo interest, my lord.
They have also challenged new bandira.
Madila.
Interest code ivre. R%
Because before the
yes, Mr. Subramania.
Before my client is agreeable to pay without going into the merits of the case, we will pay him 41,900 per yard. He was only a trainee. My submissions to your lordship on the last occasion was he admitted that he was a trainee. When he is a trainee, he is not a workman under IDEA Act. Anyway, we will not, the application itself is not maintainable. Moreover, no doubt his resignation was accepted at a later date. I am not denying that. I might not have indicated about his earlier absence, but I have produced muster roll and leave register before the labor court. That was not considered. My case is when we were following austerity measure, there was no work even for permanent employees. They did not undergo training for
6% interest from the date of petition.
ಜಾಸ್ತಿ ಬರುತ್ತೆ ಅದು ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ that was in the year 2009.
And when did you deposit the amount? When did you
I have not
deposit?
deposited the amount. I have challenged, I have opened interim stay.
So till the filing of the writ petition, when was it writ petition filed? 2014. 2009 to 2014.
No. Order was passed on 2013, 16/7/2013.
You filed the
forgo interest.
What you say regarding? Some round figure, 50,000 ಕೊಟ್ಬಿಡಿ. ಕಡೆ ಬೇಡ 6%. 50,000 is ready.
45,000 ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ ದಯವಿಟ್ಟು. I would not have bargained. 3 crore 4 crore ಎಲ್ಲ ಸೆಟಲ್ ಮಾಡಿದ್ದೀನಿ. Here I have a case, but
50,000 not 45. round figure ಅಂದ್ರೆ 5000 ಬರಬೇಕು.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ನನ್ನ ಆಫರ್ ಮಾಡ್ಬಿಟ್ಟು ತಾವು 50,000 ಮಾಡ್ಬಿಡಿ ತಮ್ಮ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ. We will implement the order. Your lordship may record my submission that I am agreeable to pay 41,900.
Order on merits
By-
only.
Huh?
We'll pass order on merits only, right?
This is not order on merits. Yes.
Then what should we do now? We have to say about
My
this.
lord, let my learned friend may agree for 45,000, my lord. Here,
Yeah,
my lord, I
50,000.
can convince your lordship on merits, but when one suggestion came from the court, I must
See, now
respect
that
the
he's
court,
litigating and
suggestion.
he is under, see, you did not accept his resignation at that point of time, no? Immediately it was
No,
not
no,
accepted.
no.
Immediately it was not accepted.
Because if there was a absenteeism, that will not be disclosed in the acceptance letter.
Correct.
Acceptance
Now,
letter
what
is
do you want
different.
this court to do? We have to pass an order, considered order, or we have to just say that you are agreeable to pay 41,500.
No,
File a memo.
no. Your lordship need not pass order on merits. Your lordship may kindly observe that I am agreeable to pay 42,000. But in the
Consent,
interest of your lordship,
consent andre, see, you file a joint memo saying that 41,900 foregoing the interest will be paying if they are agreeable.
your lordship may record my submission. I have got mandate from the client. My submission may be recorded by Idikera joint memo.
What do you say, Mr. Shekhar? 45 will do.
45.
Who is this company now? Who are that?
Company. It is automobile. It is engaged in the manufacture of automobile components. Private company.
Automatic Axles Limited has
Yes,
approached
madam.
assailing the legality and correctness of the order dated 19/7/2013 in application number 19 of 2009 passed by the Labour Court by hearing referred to as Labour Court for short, whereby by the impugned order, the Labour Court has allowed the application under 33C2 of the ID Act 1947 ID Act for short. In part, directing the petitioner to pay stipend amount of rupees 41,900 with interest at the rate of 6% from the date of petition till the date of the entire realization to the applicant. Learned counsel for the petitioner submits that the petitioner is ready to pay stipend amount of rupees 41,900 and the interest imposed by the Labour Court at the rate of 6% to be foregone. Then a counsel for the response that the petitioner be directed to pay an amount of rupees 50,000 towards full and final settlement of that. The submission of both the counsels are recorded. In the peculiar facts and circumstances, in light of the order passed by the Labour Court directing to pay a stipend of rupees 41,900 with interest at 6%, this court deems it appropriate to direct the petitioner. Respondent is directed on the petitioner is directed. This court deems it appropriate to direct the petitioner to pay 50,000 towards full and final settlement. 45,000 towards full and final settlement of the claim of the respondent. The amount of 45,000 to be paid by the petitioner within a period of 4 weeks.
4
weeks.
Within a period of?
4 weeks.
Very well.
4 weeks from the date of release of this order. Accordingly, writ petition stands disposed of. Yes.
Shall I give the check directly to Mr. Shekhar or?
Well, you can give a letter and final acknowledgement to that effect before this.
45,000 isn't it?
45,000.
Much obliged.
Without entering into the merits and demerits of this case, as the parties have, as the parties trying to resolve the dispute. This would deems it appropriate.
Pay the same. That's the amount.
Yes, 41,781.
That kind of paid I will.
Yes, you showed that order.
That should be there. But gradually, authority basis. Someone pertains to graduate. But there was an award order may not have been gradually authority. Somehow. You are paying another 30.
Yes.
42,000.
When was the order of the graduating court authority?
And it should be.
When was it? 11/1/2010.
Why don't you find an application that says payment is gradually amount out? And then we see, as per election A, the already told, the labor force spent, that not entitled to any of the release is asking, except this gradually. That also we had submitted to the labor force, that this is paid. Your Lordship took the page 19,
Yes.
Yes. It said also, that this amount is paid. That's the reason, page 19, 59, further the Assistant Labor Commissioner has also discussed in detail regarding what all payments made to the applicant is paid that only rupees 42,781 is due to them.
Correct. Under this application, what are the benefits? What are the amount which is claiming?
It pays 7,854. That was rigid. It has become final because it was not this.
What has been questioned by him in the connected writ petition? Huh? Yes. Yes. Where is the application? Where is the application filed by him?
That is 33.
33C2. That's the only point here, right? 33C2. Yes. It's here. It's available here. It's available. Just read that.
Basically, the applicant says that solvent could be passed on account. The case is responded by someone 7,855,000 around and a further claim for imposing penalty 2 times of the amount of 7,855,000. And when it is 7,855,000 is listed out in the same paragraph. 1980 and 2009 arrears of salary from to April 2009 to April 2009, that is 4,065. 3,000 per month, 51 months salary, retirement benefit. Constitutional benefits for family, more than 2 years, monthly benefit, substantial benefit, 5,000. Because at 18% from the date of 2009, 7,000. There are present cases, you challenge this order. I would like the objections regarding details. What are the details?
Look, given the details about.
That I was not to go with all the documents possible and basic things. There are finally detailed objections. The objections filed. 1687 of the police.
Yes.
But it was your option. The entire dispute the case is in paragraph. This case. The entire litigation will not have this.
Yes. Yes.
Submitted that petitioner raised claiming arrears fixation of that income. The dispute came to be referred to adjudication in reference to the point of this. Whether the demand claimed by the concerned purpose of pay from submission expense was allowed by the award dated 1 month ago. Expected what happened. The second party directly to extend the consequences right to the case of particle, such as fixing the bracelet on margin with Chindaya and getting Krishna Murthy and Shanti for the monetary rate. Leakage. Next, the responding is another is the point of this is that the demand claimed by mentioned union to regularize the service of Ramaya from the year 1980 against the management of case like this. The reference was allowed by the award dated following. The first the party consent is based on part of the Chindaya and excluding the matter of regularization and other money. Therefore, the management is directed to extend the consequential benefits to the Ramaya in accordance with the and since he is due to have been appointed on the day on which he is due to work.
Wow.
The award will be able to reflect the problem. In the meantime, the workman was by order dated 9 months. The corporation implemented the award of the day. When by 2008, passed the President by issue of PO dated 1970. The date of provision of the 29 by 80 instead of 2017. Implementation of place of provisions. Effect of 29 by 80. The figure of the place of provision of 21 by 80. Then the date of provision of and 29 by 80. But there was an option for me to fix it either with Timothy or Vinaya. Vinaya was subsequent. Therefore, we gave it earlier. The advantage. Hence, the petition was 29 by 80 on Barbara pushing. Then the date of probation has been examined by the labor court in the course of the body that the earliest of salary to be paid with the petition. It has been the only payment method. Now, how it is paid? The Russian pays the fee. The alliance was paid as well. But alliance from 29 by 80 modified at 87,000. And it was already paid because it was working as a dummy work. And it was paid while it was working, 76,000 for this period only. 76,000 is what was paid for it. The difference of 10,900. I'll check the option how this was paid to him. Was paid while check dated 1680. I've reduced that also for 2 of payment. These are the next period. From 23,391 to 8,125. This is modified at 1,60,950. And may not, it is only paid 17,409. Therefore, the balance of 1,45,559 has been paid. It may not, it is been encashed on, I have read the bank statement and they will not. There will not magically amount of calculation 42,780. Which I have already in my equation I have shown about and payment against withdrawal with this photograph. I have also brought you an option to this information.
Yes.
Next, leave encashment benefit. Their total EL available to for 40 days. 98,879 has been paid by check dated 8/9. Full payment to be paid pursuant to these two awards. And connection R1 and R2. And we come to the next page. Page 40, madam. Your lordship, you come to the last question. First item, 1,40,000. 1,45,559. This is the second item, second payment. Second payment in the sheet, page 38.
It was paid in the month of, 2008.
Yes. Because it was dismissed from service. And it was reinstated accordingly. Your lordship, you come to page 39. Item number 1.
That is light of the first arrears.
Section R5. R5. 1 lakh, second item. Here is number 2 item. 1,45,559. The last entry. And Ramaya.
Yes, yes.
Second. Without payment number 4, I go to payment number 4. So 3, your offer.
Yes, yes. Yes, yes.
Payment number 4 is past it. 10 September 2009. 98 to 878. It has been transferred to the 98. Here, by way of repetition, I will reach the order passed by the assistant level
Gratuity amount.
payment not achieved paid. Section R limit. This amount was deposited. It was assistant level. It shown as assistant level. Page 55.
Yes, yes.
45,000 is paid. Because
Yes.
we have to deposit because we cannot pay him when there is an order.
Yes,
So
yes.
therefore, there is an amount that is paid to him, and they cannot find the amount, one thing, but we find two exceptions. These two exceptions. The petitioner was released from service on 9/1/2005. Yes, the dismissal order was upheld by the we find a infringement in the infringement, he claims benefits such as bonus, uniform allowance, etc. That will be deleted. Because if your option would see benefits settlement, he has claimed for uniform allowance, bonus, and other benefits. That benefit settlement, that claim, he filed a restitution in 8757 of and WP 8367 of that came to be rejected. When that is not in fact any factor is part of
Yes. Now he's claiming is all benefits in light of this orders.
and that is rejected and he filed a return appeal. Return appeal also came to be rejected. You can also push the annexure on R12. R12, the page 56, filed by the petitioner.
When was he dismissed from service? When was he dismissed from service?
9/1/2005.
9/1/2005.
Question 74 of 2005. 72 of 2005. But the dismissal order was set for.
Now he is claiming all the benefits from 2005 as well.
That has been rejected by the connection on order.
Yes.
Page 66. This last. That is established clarified in text. However, when modifying the award part of each item, from the date of order of 8/1/2005 in the date of superannuation. However, without backdating and continuity of service for the purpose of examination.
So he was entitled from 8/1/2005 till the date of superannuation. So from 8/1/2005 till his superannuation. What was the superannuation? When was it?
According to the order, I support that it is taken into consideration in his superannuation.
Yes, yes.
Completely. By the time we lost skills, then the direction was not only to pay terminal benefits.
Continuity of service for the purpose of terminal.
Against which we are not entitled. It appears to be 226. But that's the order may not get
What is his terminal benefits he is entitled for? What is the terminal benefits he is entitled for?
Okay, terminal benefits. But what is the division bench observed that the logistics is already quite
Liberal.
and the order of the logistics is proper. The denial of activities is not proper. However, particular services, the order rejecting these statements is sounded proper as it was on the verge of retirement. And in about 2 months ago, the document the only judge should say in a liberal way that it continues to of that time. That is the related of the justice dispute side, the proper payment. That's how the order may not actually taking all this payment. Now, what is the report? There are very few obligations.
Yes.
In detail in my statement at pilot funds. That's what page something. The responding population has released the order refixing value of the applicant and produce copy of the supplementary bill prepared by the responding population. Whether the responding population is also produced a copy of the difference of pay per day, the period 82 to 91, and a copy of the bill prepared at R5 and R6. The most important document produced the responding population that exhibit R8, that is the order of safeguarding, refixing the value of the applicant, each furtherance of the compliance of the order of the applicant, 8757 of 2000, and also payment made to the applicant at R10. According to these documents, actually of the 1,37,950 and with even cash benefit of 19 was paid to the respondent. But this gratuity amount, 1,37,000 is the terminal benefit.
Yes.
The responding population is the order of the assistant labor commissioner. The second order reveals that applications approach the assistant labor commissioner on 9.2 to the day, stating that the responding population is from 9/1/2005, its last pay was 50,000, and towards its 26 of years, consequential benefits not practical. What you need to note here that during the pendency of WP, the applicant has moved this application. However, the third order was passed out clearly in 2005, wherein the assistant labor commissioner has rightly discussed the applicant not under the document to show that its pay was 50,000 and considering the last pay as 9,414 and other consequential payments added to the payment considering at 26,010 calculated and rated further, the assistant labor commissioner has also regarding what are all payments made to the applicant, that only 42,781 also important to note here that the respondent is considered that even the said amount was paid to the applicant with interest and then it was percent that is not 50,000 total to 50,800 though the applicant has denied receiving the arrears of amount of 1,45,000, 8,879 and the difference in revenue of is not produced supporting document done. Further, is not cross-examining the RWM, contradict the contents in the documents produced by the RWM. And the legal complaint and find that the activity is entitled for arrears of 1,000 from the date of superannuation. Then we have said, if it is not paid, your option is already portion itself. Pay this amount if it is not already paid. And your option is because this amount is not covered. And if the other see is paid and deposited this amount with interest. This is dispersed to the proper identification. And by the fixing this photograph, the other thing may be punished. As the then you want to identity of the state you want to pay. But you got the it's not important to directly be not to produce that the documents not because he wanted those documents ready. That is the details of the calculation. Not like how did I calculate? Even that along with the memory that is second equation. What all he had to figure out, the corporation was directed to me. And I have said it. And I've given the calculation, how I arrived at 1,45,000, how I arrived at 90.
The memo of calculation is filed along with the statement of objections.
Separate memo. In fact, I stated, in terms of the order date 11/9/2018, the following document sought by the petition is punished. And I have filed it in the registry on 3/12/2018.
So that is the very calculation which you have filed along with your statement of objections, right?
Because the court wanted to know how did I arrive at that. Even that detailed calculation is been published. Whatever you want, so the 14%, all the documents have this. To show that no injustice is possible and all the payments have been made and nothing is due.
ಹೇಳಿ ನಿಮ್ಗೆ ಯಾರ ವಕೀಲ್ ಬೇಕಾ ಫಸ್ಟ್ ವಕೀಲ್ ಬೇಕಾ ನಿಮ್ಗೆ asking me want some ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಫುಲ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಎಲ್ಲಿ ಬಂತು ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಆಫ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಇಲ್ಲಿ ಬರೀ 33C2 ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇರುವುದು ನೀವು 33C2 ನಲ್ಲಿ ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ ಇದಷ್ಟೇ ಹೇಳಿ ಎಲ್ಲಿದೆ ಬ್ಯಾಕ್ ವೇಜಸ್ ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಆಫ್ ಡೈರೆಕ್ಟಿಂಗ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಕೋರ್ಟ್ನವರು ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ತೋರಿಸಿ ಅಲ್ಲ ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಫಾರ್ ಡೈರೆಕ್ಟಿಂಗ್ ಯು ಟು ಬಿ ಆಯ್ತು ಅವ್ರು ಸುಮ್ನೆ ಹೇಳಿ ನೀವ್ ಹೇಳಿ ಹೆಂಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ನಿಮ್ಗೆ 33C2 ನಲ್ಲಿ ಅವ್ರಿಗೆ ಬೇಡ ಬಿಡಿ ನಿಮ್ಗೆ ಹೇಳಿ ನಿಮ್ಗೆ ಹೆಂಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ 33C2 ನಲ್ಲಿ ಎಸ್ ರಾಮಯ್ಯ ಅವ್ರೆ ಆಯ್ತಾ ಅಷ್ಟೇನಾ ಹಾ ಸೂಪರ್ ಅನ್ವೇಷನ್ ಯಾರಿಗೆ ಕಾಸ್ಟ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇನಾ ಸುಮ್ನೆ ಯಾಕೆ ಒದ್ದಾಡ್ತೀರಾ ಯುನೋ you didn't ಅದಕ್ಕೆ ನಿಮ್ ಕೇಳಿದ್ದು ನಿಮ್ಗೆ ಯಾವ್ದಾರ ವಕೀಲ್ ಬೇಕಾ ಅಂತ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಆಯ್ತಲ್ಲ ಮತ್ ಯಾಕೆ ಇನ್ನೊಬ್ರದ್ದು ಹೇಳ್ತೀರಾ ಆಯ್ತು ನಿಮ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿದ್ರಲ್ವಾ ಆರ್ಡರ್ ಎಲ್ಲ ಇದೆ He doesn't have to understand the consequences. To the present. ಅಲ್ಲ ಒಂದೇ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ವಿ ದಿಸ್ ಕೋರ್ಟ್ ಆಸ್ಟ್ ಮಿಸ್ಟರ್ ರಾಮಯ್ಯ ಅವರೇ ಒಂದೇ ಕ್ವಶನ್ ವೇರ್ ಇಸ್ ದ ಎಲ್ಲಿದೆ ಡೈರೆಕ್ಷನ್ ಈ ಕೋರ್ಟ್ದು ನಿಮ್ಗೆ ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಡ್ಬೇಕಂತ ಎಲ್ಲಿದೆ ಡೈರೆಕ್ಷನ್ ಎಲ್ಲಿದೆ ನೀವು ಹೇಳಿದ್ರಲ್ಲ 8577 ಅದು ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಓದಿ ರಾಮಯ್ಯ ನಿಮ್ಗೆ ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಡ್ಬೇಕಂತ ನಿಮ್ ಎಲ್ಲಾಯ್ತು ಬೇರೆ ಯಾವ್ದು ಆರ್ಡರ್ ಆಗಿದೆ ಈ ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ಈಗ ಆವಾಜ್ ಈಗ ನಿಮ್ದು ಶಬ್ದ ಬೇರೆ, ನಿಮ್ದು ಸೌಂಡ್ ಬೇರೆ ಆಗುತ್ತೆ. ನೀವು ನಾವು ಹೇಳೋದು ಕೇಳ್ತೀರಾ? ಹಾ, ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಇದೆ, ಅವರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತೋರಿಸಿ ಅವರಿಗೆ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಜಸ್ಟ್ ಹೆಲ್ಪ್ ಮಿ ಔಟ್ ವಿತ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. 8757 ಹಾ ಎಲ್ಲ ಗುರ್ತಿದೆ ನಿಮ್ಗೆ. ಲಾಸ್ಟ್ ಪೇಜ್ ಓದಿ. page 66. In the objection statement ಇದೆ ನೋಡಿ. ಯಾಕೆ ತಂದಿಲ್ವಾ? ಅದ್ ನಿಮ್ದು ರಿಟ್ ಪಿಟಿಷನ್. ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ನೀವು ಹಾಕಿದ್ದು. ಹಾ, ಅಲ್ಲ ನಿಮ್ಗೆ ನಾಳೆ ತಗೊಂಡ್ ಬನ್ನಿ. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ is present to both the petitioner counsel and the party in person. Party in person request for tomorrow. This matter tomorrow. ನಾಳೆ ತಗೊಂಡ್ ಬನ್ನಿ. ನಾಳೆ ಮತ್ತೆ ಮರ್ತು ಯಾಕೆ? ಅಲ್ಲಂದ್ರೆ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ಈಗ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ನಿಮ್ದು, ಈಗ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ಅಲ್ಲ ಮತ್ತೆ ಫೈಲ್ ತಗೊಂಡ್ ಬನ್ನಿ, ನಾಳೆ ಬನ್ನಿ. ಮತ್ತೆ ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಗಿವ್ ಹಿಮ್ ದ ಪೇಪರ್ಸ್. ನಿಮ್ ಪೇಪರ್ಸ್ ಇಲ್ವಾ? ಇದೆಯಲ್ಲ ನಿಮ್ ಇನ್ನೊಂದು ಕಾಪಿ. ಸೋಮವಾರ ಅಲ್ಲಂದ್ರೆ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ, ನೀವು ಪೇಪರ್ಸ್ ತಗೊಂಡ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ. ಹಾ, 23 ತಗೊಂಡ್ ಬನ್ನಿ. The statement of objections, there is synopsis in that. There are synopsis and statement of objections of yours. Just make yes. Along with the synopsis.
Because I also had done regarding
so along with the annexures, you just mark with the in the synopsis.
Yes,
You make him understand, Mr. ನಾಳೆ ಬರ್ತೀರಾ? ನಾಳೆ ತಗೊಂಡ್ ಬನ್ನಿ. Day after tomorrow. ತಗೊಂಡ್ ಬನ್ನಿ.
20 AV Srinivas.
When did you file? Have you filed or not filed? See, now the question is whether this Lokayukta had any jurisdiction to issue notice or issue notice to the hold inquiry against the petitioner. They are not a government servant. Alva?
yes, my lord, your lordship has heard the matter now.
No, that is what this was. Yes, sir. No, whether it has been adapted. So whether that authority would, the Lokayukta would come under the purview of authority.
Same regulation, which says other authorities.
That is why we asked him whether other authorities include this Lokayuta. Where is that? Where is that? 21 for regulations. Where is the regulation? Have you produced your regulation? Yes. 21 ನಲ್ಲಿ ಏನಿದೆ?
Regulation 19/20/21 remove the other authorities in the letter. Disciplinary authority. Disciplinary authority and definition. Definition page number 4.
Madam, the question is other authority ಎಲ್ಲಿದೆ?
They say other authorities under remove other regulation number 20
ಹೌದು. That is already there. That is there in rule 20. It says the corporation or any other authority. So this any other authority, does the Lokayuta come under the purview?
The corporation or any other authority enforced by general or special order. There is no general or special order. Or issue disciplinary proceeding whether it is any corporation subject. Directed the disciplinary authority to corporated channel on whom the disciplinary authority competent informed under the regulation any of the penalties. I don't there's no authority to impose any penalty under this.
That was the question to you or to the Lokayuta. The corporation or any other authority empowered by it by general or special order may institute disciplinary proceedings against any corporation servant. Direct a disciplinary authority to institute disciplinary proceedings against any corporation servant on whom the disciplinary authority is incompetent to impose under those regulations any of the penalties specified in regulation 18. This any other authority would be in the context of this corporation limits only, not in the But then any authority in the context of this disciplinary authority only, like the delegation of powers or the authority which the corporation would not the local. Is it not? If you read the provision or the rules.
I guess your lordship regulation 21. There are disciplinary authority or any authority to which it is subordinate or any other authority empowered in that.
Where are you reading? Where are you reading?
21.
Should say any other authority in the context of disciplinary authority, not the any other to which it is subordinate or any other authority empowered in that. So there is an empowerment of the
One authority is subordinate authority.
correct.
Or any other authority. Whether it is laws come with state, the authority is subordinate authority. Director empowers the authority is the subordinate. That's subordinate. Or any other authority empowered.
So everything is by the corporation. See, or any authority, other authority empowered in that behalf by the corporation. So the corporation has to empower them. This authority has to be given.
It's an order by the subordinate. It's an order of the advice
By the local. Where is that order? It is important. Yeah.
And the petitioner for before you have for the legislation order.
What is that order? Just a moment, madam, just a moment. Yes. Yes, sir, where is it? The KCS for it? KCS and the CCA. If we consider the order passed by this court, then the order entrusting the matter to the Lokayukta is not proper in light of Sanna Mallappa's case. Then they have to be, you have to appoint an inquiry officer and so then their petition has to be allowed in that context. If you don't, what is that objections they have to file now? Well, this court, while passing this order in March 2023, had considered the division bench order. Today, Dawar.
Your lordship's order, it is considered because it says we don't have a CNA regulation. So the court said, this honorable court said this can be, don't has authority for the but even my lord, they have the CNA regulation and the dictionary is all for the CNA regulation and the division bench says when there is, it is not important. KCS is not important or it could be clear in the regulation that the KCS and CCA has not where has no authority. This page number 29 of the there is a law.
So this San Mallappa's case and this Dawar case are one and the same or different? Sanna Mallappa's case, what is that Sanna Mallappa's case? Madam, what is that Sanna Mallappa's case? See, there are two orders of the division bench, same bench. Dawar case and Sanna Mallappa. In Sanna Mallappa's, they said Cridle was there before the court. So they said.
Cannot be the order passed in a case, the order passed by the Supreme Court.
Room 4A ಕೊಡಿ. Lockout, sorry? Just,
Page 7, where it says, the other on the council would also consider the CCA rules 1950 has been adopted by the Karnataka Housing Board. Rules under the day of which we have here. That's why your lordship has ordered the Provident has the jurisdiction to board and inquiry. Here it was been adopted. In my case, CNT regulation has not adopted CCA rules, my lord.
So in light of the non-adoption by the respondent, so this is the interestment to the Lokayukta is not proper according to it.
In my case, the CMT regulation has not adopted KCA Sorry, it is a revision when it is not adopted. The Lockout has no duty to hold an inquiry.
Is it so? It is not adopted. So who has to answer? Is Rule 14A is been adopted? Is it adopted? See, your contention, the Lokayukta's contention is every way the same. He is an authority. But then the Lokayukta is not an authority, it's a quasi-judicial authority. Is it not? It is not an authority. All the way, the contention of Mr. Arbatti, the Lokayukta, is that the entrustment and he is an inquiring authority in light of this regulation of 21. He is not an authority. He cannot be treated as an authority for them to refer the matter. They are all quasi-judicial authority. The judgment to be quasi-judicial. This contention was not taken into consideration by the division bench of this court in Udai Devara. It's not. If CCA rules, that is one thing. Even if they don't adopt it, the procedure is he cannot be treated as an authority for direction and entrustment, and that too when it is a public servant. Government servant and appropriate government would be the state government to issue. I mean, state government has not entrusted this to the Lokayukta. Again, the proceedings go. You let them initiate all disciplinary authority. Why was it sent to Lokayukta? At request of the respondent, please this matter on 23rd. 23rd. ಇದು judgment means different and the CCA yeah. Mr. Somshekhar.
I appear for the petitioner, my lords. My lord, this is regarding the misconduct of theft which the senior had argued before your lordships, my lord. And thereafter your lordship suggested that the matter could be settled.
What happened now after that?
We spoke to the management, my lords. They are willing to pay an amount of rupees 5 lakhs, my lords.
In lieu of
The
reinstatement.
workman is, my lords.
In lieu of reinstatement.
Please, my lords.
Yes, who is appearing for the respondent? Mr. Srinivas.
Srinivas K, my lords.
AJ Srinivas is different and this K Srinivas is different. Who is
Yes.
this? Why?
He's there, he's there.
See, the order, the dismissal order is based on the charges which were leveled against him of theft. If at all the court comes to the conclusion that the order of reinstatement is not proper, if you set aside the order, you would not be even getting anything what they have been making an offer. ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್ ಅಲ್ಲಿ VC ನಲ್ಲಿ ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಇದೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಮತ್ತೆ ಅಟ್ಲೀಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಆಲ್ರೆಡಿ ಹರ್ಡ್. ನೀವು ಸುಮ್ಮನೆ ಒಂದ್ ಸ್ವಲ್ಪ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ on Monday. We will release on Monday at request of respondent counsel. Monday, madam.
Please, my lords.
ಹೇಳಿ ನಿಮ್ ಸೀನಿಯರ್ಗೆ ಆಫರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಮತ್ತೆ ಮುಂದೆ ಬೇರೆ ಏನ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳೋದು ಬೇಡ. ನೆಕ್ಸ್ಟ್. Yes, Mr. Bhatt.
Number 22, I appear for respondent.
Yes. This matter was heard or it is to be started now? Yes, pass over, Mr. Anand.
Madhyana, Swami, 2:30.
Madhyana. 2:30. After one partnered matter, we will take up your matter.
Agbodu. Oblige.
Yes, Mr. Sanjeev. What is the misconduct? ಯಾವುದು ಮಾಧುರಿ ಪಾಟೀಲ್ ಕೇಸ್ ವಾಟ್ ಈಸ್ ದಿ ನಾಯಕ ಪರಿವಾರ ಏನು? $17B from when to when? From the date of petition, yes. 5 months wages. Just a moment. Now he knows that he is not entitled for anything. Evaginda. From what period to what period, Mr. Srinivas? See, submission of Srinivas is as though it is 100% workman is never wrong. Yes. He is never wrong.
I think what was wrong.
Yes. Age is 9 years difference. 9 years. No, see, a lady may say her age is so and so. He may deny her age, that she is not exactly that age. She may say, no, I'm not born this year, I'm born a little later, or rather next year. I mean, if it is 74, she may say it is 75. If it is 75, she'll say 76. But now this is not a case of 1 year or 2 years. It is about 9 years. Nobody would have made a submission, rather he would not be ignorant to the extent of 9 years. ಎಷ್ಟಾಯ್ತು ನಿಮ್ ವಯಸ್ಸು ಅಂತ ಕೇಳಿದ್ರೆ 40 ವರ್ಷ ಅಂತ ಹೇಳೋದು. 10 ವರ್ಷ ಆದ್ರೂ 40 ವರ್ಷನೇ ಇರ್ತಾರೆ. Correct. When did they realize that you were not that age? 9 years you have worked in advance.
Once before my retirement, they become related and they expect work from me. They give me a medal for having done very good.
And then at that time, they say, all that I have now is question of non-payment of something we does not arise. What should be kindly taken?
Now,
What
this-
is asked by this honorable court? Asking to be that. I'm asking, I'm willing to post the equal court. What may kindly.
No, we are hearing this matter on merits, right? We are hearing on merits.
I'm restricting my claim.
You don't want to contest on merit.
Whatever the court is, merit and not open. I think that the lordship is really the court, but it's other aspects. One of and in the
The writ petition by the management.
Actually, is defined to the line, but having entered that. I think the order of management. That's the one. But you see, this part of one of the management.
When was the award passed? When was the award passed? It's March 2012. And when was this order passed? When was the order of superannuation? When was the superannuation? And when, according to you? You are because of 10 years of addition. So 8/3/2012 is the award passed by the Labour Court. And then 7/5/2000. So you are entitled for only these 2 months. Is 7/5/2012. No, they have this order has been recorded in on 7/5/2012. 8/5.
8/5/2010 is 5 days of birth. So 50 years from 8/5/2010.
2010.
8/5/2050 is my date of birth.
2000? 2000? ಅಲ್ಲ 1950 ಇವ್ರೆ. So then 62 years. 60 years is how much?
8/5/2010.
8/5/2010.
So I will return.
No, now this court said you are entitled from the date of award till the date of superannuation. So you would be. It would be only after the award you have. He said it is 7/5/2012. So you are entitled for this 2 months. 2 months packages.
2 months, 17 days. 2 months.
2 months. Yes, now what is that you want?
I was entitled to wages. One.
Please, what was your salary? So you want only this 2 months salary to be paid to you? What is your grievance, Mr. Srinivas?
We had spoken here, the street performance. That is how the matter got.
Then what happened before the Lok Adalat? Did you agree? Did you agree? Then pass over. Okay. See, they would be either entitled, strictly speaking, only for 2 months, or if at all you have agreed, pay him that amount. What would be his salary? If you have agreed. Tomorrow. Okay. On both sides. So 8-3 is the award. 7/5/2012 is the superannuation. Your contention, you're entitled for 17B wages. For period of? For the said period. Yes. Yes, Mr. Shekhar. Shekhar. Okay. Pilfarage, huh? ಎಷ್ಟರಿಂದ ಎಷ್ಟು?
38 days. Content, additional charge as per lecture. 3 months. In fact, was earlier Milad was looking at Chennai depot. Was kept at a suspension for an allegation of misconduct. That 2005 suspension order was revoked. Suspension order was revoked. They deputed to Ascent depot. That he did not aware the deputation order and transfer order. Even revocation order also not reached the hands of the workman. Hello, Milad, when the all notice was received in the month of last week of July 2005, Milad, he reported for duty by producing medical records. And in the meantime, Milad, he sent district post to the Chennai depot. That the same was returned to receive the.
When was the order of suspension?
Suspension, Milad, is not forthcoming, but they stated that Milad, the revocation was done on 2005.
16/3/2005. So, you remained absent from 16/3/2005 to 5/8/2005. According to you, the suspension order of revocation was not brought to the notice of you, and you were not aware about, and hence you remained absent.
He also submitted the leave application to the register post. It was returned. Refusal to accept the same as per Exhibit W2. Saying that you were transferred to Ascent division, Ascent depot. Patna depot manager refused to accept it. Everybody, he sent leave, they have to have received and forwarded to the division office. He did not do so. They have had immediately after visit of the call notice.
When was the call notice you received? 5-7. Five seven. The refusal ಆಗಿದ್ದು you have produced at exhibit W2, na?
Trial notice, exhibit M2
Dated
dated 30/7/2005.
37/2005.
That's serious.
Records ತೋರಿಸಿ. Records ಇದೆಯಾ? Will summon the records. Call for TCR forthwith. ಬರ್ಲಿ. Next.
Number 35.
Next, madam. Records ಇದೆಯಲ್ಲ? All they have produced.
Documents also are ready. The appointed the post of driver and they start training.
Yes.
And that training period is a 0 period. But as far as services concerned. So therefore, my lord, and later, my lord, resigned from service. On 11/6/2013. Then, my lord, he claimed it was found that my lord is not eligible for gratuity because he has not completed 5 years. There has to be, he has to complete 5 years.
Yes.
Now, therefore, he filed an application. Usually, the first thing has been 7 years. In his 7 years, he is 2 years of training.
Whether he is entitled, whether the trainee is entitled for the gratuity amount. That is an issue which is pending before the apex court, no? That is not pending.
The case that is pending before the court is whether they are entitled for the version of basic wages, here is the road to the basic wage. That's the case. But I stated also the ground number 1. Gratuity is calculated in terms of regulation. Because in the appointment order, we have said so that they are entitled to gratuity only in terms of. So now what is being calculated is, the appointment order will not have produced. Pending on Annexion A, page 11. The relevant portion will not page 14. Your object to see clause number 7. Given a name of value,
Yes, yes.
Rajaniya body 64. Downgrade and Nadathai ಮತ್ತು ಶಿಸ್ತುವೇನ ಕರ್ನಾಟಕ ರಜೆ ಉಪದಿನ ಪಾವತಿ 92 ಹಾಗೂ ಕಾಲಕಾಲಕ್ಕೆ ಹೊರಡಿಸುವ ಇತರ ನಿಯಮಾವಳಿಗಳಿಗೆ ಒಳಪಟ್ಟಿದೆ. The appointment order specifically is issued saying that you will be paid gratuity in the terms of the law. And my lord, here the erroneous finding is
both the authority have taken as 7 years.
Yes. One is 7 years, my lord. The second one is, my lord, the calculation has been made in terms of the regulations. Contrary to the appointment order. The appointment order says, my lord, because from 2010 onwards, my lord, whoever has been appointed after 2008 onwards, the corporation, my lord, the board has taken a decision, my lord, that they will be paid
as beneficial act, no, they have to be whichever is benefit.
I cannot pay them, I have to ensure that they get in terms of the act. Therefore, I have taken a decision to pay all the benefits, gratuity only in terms of the act.
What was beneficial for him?
Regulations. Regulations is not active. We have said so.
Only in respect of trainee.
Yes.
Only in respect of
training. To all those who have been
up to 2000. Up to 2000.
Because So we have taken it's a policy decision, we have taken because there was a lot of litigation, and so many aspects.
So after 2004, any appointment after 2004, they would be as per the act, not as per the regulations.
And it's not that he's not even putting 5 years of service. That implies that he has to pay. That's what. Record said Bekal.
Heard in part. Heard the learned counsel for the petitioner in part. The learned counsel for the petitioner. Learned counsel for the respondent 6 times. This matter for further hearing on 23rd. Okay. New Madiala, why should your senior come? Huh? Privilege to go bedi adarku. You be ready in one matter at least. Yes. Huh? ಏನು ನೋಡೋಣ ನೀವು ಬನ್ನಿ. You should at least look into the file ಅಲ್ವಾ? ಆಯ್ತು ಆಮೇಲೆ ಇದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡೋಣ. ಇದಕ್ಕೂ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ. At least in some matter you should be ready, no? As a matter of right, ಇಲ್ಲ ನಮ್ ಸೀನಿಯರ್ ಇಲ್ಲ ನಾನು ಟೈಮ್ ಕೊಡಿ ಅಂದ್ರೆ. Next.
Lords, in serial number 26, my lord, I appear for the petition in the connected matter, my lord, and responded in the first matter. My lord, by virtue of the previous order, my lords had directed government advocate to verify the status of the application that is pending before DCBC for verification of the caste of the respondent, my lord. My lords, government has advocate has to give a report on that aspect, my lord.
Kindly go to the first order part that is whether it is landing the interim order. That's the kindly see. The petitioner is directed to refer the matter to verification of the caste certificate.
2017. In which order sheet?
Dated 30th November 2000.
In which writ petition?
Petition filed by the management. That is 51251.
Connected with petition, my lord.
2017. Kindly see, my lord.
The order sheet is
At the time of granting of the interim order, last paragraph, the petitioner is directed to refer the matter to verification of the caste certificate to the district caste verification committee. The DCVC is directed to give its finding within a period of 1 month from the date of receipt of the reference or application made with the
2000 when it order your 6/6/2018.
30th November 2017, passing 51251 of 2017. The last paragraph. The petitioner is directed to refer the matter to verification of the caste certificate to the DCVC. The DCVC is directed to give its finding within a period of 1 month from the date of receipt of the reference or application. Till date, my lord, there is absolutely no progress shown by the management. Because the management was directed. Unfortunately, my lord,
So according to you, they said on the last equation that they have forwarded this caste certificate to. They have produced the document. That's how this order came to be passed. We have to know whether the management has done its part of work and then whether it is being forwarded.
that is all. Unfortunately, my lord, the worker is dead. His wife is brought on record. The most unfortunate thing is by the time the award was
You are
passed.
appearing for the workman. You are appearing for the workman.
By the time the award was passed, he had attained superannuation. So there was a direction for reinstatement that could not be fulfilled. Now, by the time the matter reaches for final hearing, he is dead and he is going to. The only issue is whether he belongs to that particular community or not, because management did not do any efforts. That circumstance.
No, my lord. My lord, that is not the right submission, my lord. My lord, we had constantly followed it up. And despite that, when we did not receive any notification from the DCVC, my lords had directed the government advocate to verify the status and then file a report on that regard.
What is that letter? 2012-2017. Yes, madam. What is your instructions? You were directed to get instruction as to what is the status of the DCVC. Yes, you get instruction. In your presence, this order was passed, the earlier SCGP. Password. Yes, next.
DC Prabhakar.
I appear for the petitioner in this
Here
case.
for the respondent.
I have one matter
Somshekar
at
appears for
3:30.
a workman here.
Yes, Somshekar is appearing for workman. My lord, I am fully ready in the case. Can I start at 2:30, my lord? Because
After part-heard
3:30,
matter.
I have one part-heard matter at Kalaburgi bench before Justice Sanjay Gowda, my lord.
There is one part-heard
If
matter
last
going on.
permits me, I will commence at 2:30 itself.
No, not at 2:30. You
ಅಥವಾ
come at
ನಾಳೆ
3:30.
ಹಾಕೊಂಡ್ಬಿಡಿ 2:30ಗೆ. There is
ಅಲ್ಲ,
urgency
3:30.
for other side.
3:30 you come, Mr. Subramanya, come at
3:30ಗೆ
3:30.
ಇದೆ ಅದು 3:30ಗೆ I have part-heard matter at Kalaburgi bench before Justice Sanjay Gowda. ಅಥವಾ ನಾಳೆ ಬೆಳಿಗ್ಗೆ 2:30ಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Yes, tomorrow at 2:30.
Other side they are saying there is urgency. I may not be
Tomorrow at
justified in
2:30.
asking. My lord?
Tomorrow at 2:30.
Very well.
Yes,
Very
ma'am.
well.
Yes, ma'am.
Yes. ಮಧ್ಯಾಹ್ನ ತಗೋ. Yes, what is that?
28. I have informed the other side. Short accommodation.
28. 28.
28.
You are appearing for whom? Murlidhar Peshwa. Yes, Mr. Swami. So council seeks time at request this matter next week.
Number 49, my lord. Serial number 49.
Taking time.
My lord,
Okay.
Picture is not well.
So council submits that Murlidhar Peshwa is unwell. And seeks adjournment at request. This matter we talk about.
my lord, serial number 49, my lord. We need records, my lord. It's a case of absence for 8 months. And we need to refer some evidence and then cross-examination.
Here ಮಾಡಿದ್ದ ಇದನ್ನೇ matter, Mr. Shekhar?
49.
You heard the matter 49?
Records ಬೇಕು some.
Madam, matter is already settled. You are not even aware about it.
No, your management has not told me, no. Has not informed me.
That lady's matter, some absence was there. Now the corporation has already, your officer is before the court. Is it not?
No, nothing has been reported to me.
Everything is settled. Please come to the court.
Yeah.
2:30 you come to the court. Is memo ready there? Please inform her. Madam Nirmala, please come to the court.
Okay. Okay.
What happened, Mr. What is your proposal? We are not going to be taking this matter day to day. Allah, see, Mr. You should understand. Allah. When the iron is hot, you have to cut it immediately. Otherwise, it will never work. Like tomorrow, for reporting settlement, if any. ಈಗ ಎಷ್ಟಕ್ಕೆ ಒಪ್ಪಿದ್ದೀರಾ ಈಗ? That's what she's been telling from day one. ನೀವು ಒಂದ್ ಮನೆ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ, ಎಲ್ಲ ಆಸ್ತಿ ನಿಮ್ಗೆ ಬೇಕು, ನೀವು ಮಕ್ಕಳಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ. Not even, no, she is not even your mother. No, Allah, I'm telling you on the merits. Yes, what you say, Mr. Counsel? ನಾಳೆ ಇಟ್ಕೊಳ್ಳೋಣ, ನೀವು ನಾಳೆ ಹೇಳಿ ಮತ್ತೆ ಫ್ರೈಡೆ ಇಟ್ಕೊಳ್ಳೋಣ, ಟುಮಾರೋ. ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ವಾ ಅವ್ರಿಗೆ? ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ after tomorrow, not Friday. ನಿಮ್ ಬಿಸಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಆಗುದೇ ಇಲ್ಲ.
Friday after that.
Thursday.
Proposal
Level best ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ this court has already said what was going to happen. ಎಷ್ಟು share ಬರ್ಬೇಕು ಅರ್ಧ ಅವ್ರಿಗೆ. Friday for reporting settlement or to argue the matter on merits. Which is that? $26, huh? Who's the other counsel? SCGP seeks time to make submissions in light of the order passed by this court on what is that full order? ಇಲ್ಲ ಇನ್ನೊಂದು ಆರ್ಡರ್ ನಾವು ಮಾಡಿದೀವಲ್ಲ. ಒಂದು ಆರ್ಡರ್ ಇನ್ನೊಂದು ಆರ್ಡರ್. To get instructions in light of the order dated 25/1/2020. This matter tomorrow. Please. 35. You appear for the respondent. And you. KVO, why is it listed today? Is that request of the petitioner counsel list this matter? Who has moved this petition? Take this matter next week.
Serial number
45, 19. Yes, Madam Renuka. 45 at the meeting. 49, huh? Who has died now? Petitioner has died. Petitioner is a company, the union alva. Petitioner's counsel seeks time. Leave this matter week after that.
Serial number 43, my lords, with the permission of the Honorable Court. Serial number 43, my lords, I am appearing for the petitioner in the first case. My lords, I seek for 2 weeks time to file rejoinder. My lords, I'll inform Mr. Nayak also. He had served the objections on us. We want to file a rejoinder to the objections.
Request of the petitioner counsel. So in WP 437 that is please this matter week after next.
Obliged, my lords.
Mr. Counsel, you should come at 10:30 to move a memo. See, in spite of you coming late by 2 or 3 minutes, even in spite of that, we take this memo, not at 1:30. No. What is that? End of the list, not end of the list, tomorrow.
Sir, serial number 43 date ಏನಾದರೂ ಫಿಕ್ಸ್ ಆಗಿದೆ ಸರ್? Sir, 43.
For 4 and 4.1. Monday 2:30.
It have been mentioned in the first hour itself, right?
Monday.
The other senior counsel was there here in the morning hour. When do you want?
Monday 2:30.
Serial number 4. Which are the matters?
58, 59 and also 60.
Matters, yeah. On 23rd.
60 also it may be taken.
Serial number 4, 58, 59 and 60.
60. ಇಲ್ಲಿ ಜೊತೆಲಿ ಅದು ಸೇಮ್ RTN. ಟೆಂಪರರಿ ಪರ್ಮಿಟ್ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಆಗುತ್ತೆ and entry ಮಾಡಿದ್ರೆ extended in 4, 58 and 59. ಅದೇ ಇಲ್ಲೇ ಜೊತೆಲಿ
ಅಲ್ಲ ಅದು ಬೇರೆ ಇದ್ರೆ why should be connected?
ಟೆಂಪರರಿ ಪರ್ಮಿಟ್ ನೋಟಿಸ್ ತಗೊಂಡು ಇವತ್ತು ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿದೆ.
ಇಲ್ಲ ಯಾವುದು ಟ್ಯಾಗ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
4.1, 58 and 59 ಎಂಟ್ರಿ ಮಾಡಬಹುದು.
4 ನಲ್ಲಿ 58 ನಲ್ಲಿ 59 ನಲ್ಲಿ entry model granted earlier is extended the next date of hearing. Among 60 ಅವತ್ತೇ ಲಿಸ್ಟ್ ಮಾಡಿ ಡಿಸ್ಕೌಂಟ್ ಅಂತ Have you informed the other side? That it is to be petition council, this is after 2 weeks.
24.
Huh? 24. Council, senior counsel, that is, will take your matter at 3:30. 3:30.
Very well.
Senior counsel, your matter we will take. Pass away.
Nandu, your lordship will see my matter.
Serial number 3.
3. Where the PF department in the morning said they'll come back.
Yes.
The first person has attained the age of 3. Now the demand letter has been sent to him, but acceptance has not been. Therefore, after that, they are supposed to pay that amount back to the authority for the higher wage. That has not been done in any of the cases.
Then what is this memo and what was the earlier memo?
Earlier memo actually was that they had sent that it was under the now they have told me what is the right.
Then they could say that it is under process. Suddenly what happened to them?
No. In fact, the demand letter has been sent to the employer, acceptance has not been received at the level. So what
Yes, senior counsel, they have filed a memo indicating what is the status of this higher pension and also that they have not received any acceptance from your side, it seems.
Not more than 151 people have transferred the money from account number 1 to account number 10. And this transfer has taken place. After everything is over.
Now what they say is, now this is only in respect of the 16 workers. What about the others? What about this? There are 100 employees.
No,
They say there are other workers also. And these are what senior counsel finally memo which has been filed by them. It pertains to the 16 petitioners. Is only 16 petitioners involved in this petition?
26 petitioners are there. And out of which some of them have paid amount also. As directed by their office. They are waiting for the final order. After taking money from me, the differential amount they are making me wait.
No, what?
And in the retired category where I filed another petition, batch of petition, 21 people have applied in March 2023 to August 2023. And till now, they have not got a single communication from them. More than 1.5 years. What are they talking about? 14 people, 13 people and all that. When there are 354 people.
How many workers are here?
Those who are before the court are a limited number. But from the same factory, 354 people have applied. They have returned to others to make the payment. Differential payment is made for 151. What are they doing? Why are they talking about petitioner when it's an institution of the government?
No, Mr. Senior Counsel, Murthy sir, they have filed an details of pertaining to some 16 workers who are the employees of your establishment to contend that these applicants' pension, they have not yet received any remittance from them. Is it so?
What do they say about 151 people who have paid money?
According to
who have
them,
already transferred. Merely because they are not before the court, they want to take a technical condition. 26 people are there. If 16 people have not returned or addressed anything,
all the employees who are retired, whether their entitlement of higher pension has to be determined in light of the judgment of the apex court in the case of Sunil Kumar. What have you done?
2 years are over.
Now these respect of 16 people,
Forget about
demand notices have been issued.
Forget about 16. What about the others then? Now 16 you have just bought it. How many employees are there in this establishment? And is it fair on part of the department to say that we are not going to give only those persons who have been related? Then not like that. Where is the material to show how long the process will take? Once there is a
remarks have been issued to them. Now what happens is the employer has to send
Madam Nandita,
have to pay that amount. Now in these cases the payment is not paid. How can we pay the?
you are only talking about the 16 employees. What about the other employees? What happened to them? What happened to them? Then is it fair and non-part of the department to keep these petitioners who are entitled for this higher pension at the fag end of?
Now, it is not, they would have been issued to them also.
We don't know. We are not placed anything on record here.
I think some time.
By how much time the department, whenever they have to seek recovery, they do it immediately. When the question of payment comes, they never do it. Is it not? Is it not? No, no. That is the case. That is how we've come across so many matters. When you want to recover the amount, you do it immediately. And when you have to pay something, you will never do it. It is.
The higher pension, thing is that there are a lot of employees.
A lot of employees again, you notice Kodalva, demanding notice, you will not give. You would demand them money when you want them to pay. And when you want you to pay them the amount, you will never do that. That is how it is.
No, 2 years, my lord, 2 years.
This is pertaining to 16 workers. What about the other workers? What about the other employees? See, this is not how the department has to do. Let me tell you very frankly, in so many matters, you should demand notice under that, which is that Security Act, international workers, you all issue notice immediately. But then when it comes to payment by you, it is never done. It is never done. This department plays nicely with the citizens. When they are entitled for a higher pension, why don't you give it to them? There is a decision of the apex court which says you have to pay.
Now I have to check up whether all of them.
This has been. It's not you. It's the department which we are telling. 2019, the order was passed way back in the year 2022. They were entitled for this higher pension. They had to do it. They had to do it within a specific period. Where is that? You tell us by which time you will pay that amount. We will take that on record.
No, I cannot say the payment.
Then ask the concerned department person. This is.
Even the other cases also.
Where is the details? Where is the details? Where is the details? How many days you want this matter to go on? Once you said it is under progress, and by this separate memo now you say that they have not paid the remittance amount.
I will make the same tabular form whether they have remitted or not, and according wherever it is paid, I will take it.
The senior counsel for the petitioner submits that the benefit of the judgment of the apex court, the case of which is that
Payment.
Sunil Kumar. What? Just give the details of that. Judgment of the apex court in the case of Sunil Kumar.
Sunil Kumar workers.
Sunil Kumar, Employees Provident Fund Organization and another, etc. versus Sunil Kumar B and others. Reported in AIR 2022 SC 5634. The counsel for the respondent submits that files a memo producing the status of the applications filed by the petitioner. And it is contended that the petitioners, certain petitioners have not remitted the dues as per the demand letter. The respondent is unable to substantiate about the other employees of the petitioner company limit. Learned counsel seeks time to file the details and the status of the petitioner's employees by next date of hearing. This matter on 23rd. Oh, so this will not serve the purpose. You make an effort. You make an effort by 23rd. By 23rd. By 23rd. Let us see. How pass out is it? Yes, Lakshman Rao. What is that, Mr. Shekhar? 49 settled. Yes, madam, you are not even aware about the settlement. Huh? What? What's the? You should be aware. That lady was present on every day. She is present every year. He thought you would be aware. Kodi memo kodi. You have settled, right? $49 million. No, I will buy both the sources. That the parties have agreed to settle the dispute, resolve the dispute, and seeking for modification of the award passed in ID number 7 of 2017. The joint memo reads as under. Next, 1 to 3 paragraph 6. The light of the joint memo, the respondent corporation has agreed to reinstate the petitioner into service with continuity of service, consequential benefits, back pages from the date of dismissal, that is 1/12/2011 till the date of actual reinstatement. Further, the service of the petitioner prior to the order of dismissal is protected, and the default cases pending as on the date of dismissal would be continued, continued from 1/12/2011 till actual reinstatement is treated as not continuous period under section 2A of the ID Act, and the petitioner is not entitled to claim terminal benefits, including gratuity for this period. The joint memo, next one, the joint memo is taken on record. In light of the joint memo, the petition stands disposed of. Eವಾಗ reinstatement? Eವಾಗ ಮಾಡ್ತಾರೆ? By how many days you will reach? Modified the impugned order passed by the in ID number 7 of 2017 is modified in terms of the joint memo. The respondent corporation to reinstate the workman within 4 weeks from the date of receipt of this order, and the petitioner would be entitled as per the joint memo. Petition. 10 one correct.
Affirmative.
49. Is it regarding that apex court judgment? No.
Have the paper with that. That is applicable. The date of retirement.
In date of retirement has to be looked into. Retired on 31/1/2008.
It's only now that article 3 1 4 2000 1 2 article 3 2000
5 alva.
2001 to 2006. 1 4 2006.
If it doesn't come, what to do? Is already, huh? We'll see Passover till 4:30. Be patient.
Number 15.
Yes. Only 7 employees are involved in this petition, right?
Three.
Just 3.
Only
And what-
3.
What
Number
about
of transfers were 7, but 3 have raised the dispute.
Others have reported, they're working.
others are reported?
Illa, Swami, illa.
Okay, Vignesh, they're
Anyway,
working.
that's not the subject matter of the red petition.
Correct. Mr. Kuttappa, there were 2 complaints, that is one of 96 and one of 92.
Yeah. But all put together 3 employees. Both put together.
Why is it mentioned that 7 employees here?
ಅವರೆಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಕೆಲವು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಕೆಲವು ಮ್ಯಾಟರ್ಸ್ ಹ್ಯಾವ್ ಬಿನ್ ಸೆಟಲ್ಡ್
Out of the 7, some of them
petition
settled.
blood, only 3 people are involved.
Only 3.
Koragappa
Only
Pujari,
3, correct.
Muniyappa
And
and Desai.
before the labor code, there were 7, right?
Illa, 3. Only 3.
Who is that?
One is Muniyappa, as senior counsel said. The other one is Desai. Then Koragappa Pujari, 3 of them.
And you have mentioned so many in your complaint. So many
Illa,
persons.
more. It's confined to 3 of them.
The order of the labor court is only confined to 3?
3, only 3.
Where do you find in the by order of the labor court? Why 2 complaints were there? One of 96 and one of 98.
One is exposed to, another one. One complaint libro. Innondrili one.
You have challenged only the CA number 1 of 96?
Both.
Have you challenged both?
Both, I have challenged both.
ಎರಡು ಇದೆ.
One of 96 connected with
One of
98.
Prayer ಅಲ್ಲಿ first prayer.
One of 96 and one of 96. Yes. So only 3 workers. Who are they? Umesh? Umesh is there?
ಅಲ್ಲ ಉಮೇಶ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಕೊರಗಪ್ಪ ಪೂಜಾರಿ,
ಮುನಿಯಪ್ಪ and Desai.
Though you had filed this complaint on behalf of 7 workers, this claim was restricted only to Koragappa, Pujari, Desai and Muniyappa.
Yes.
Where do you get in the order of the labor code to that extent?
ಇಲ್ಲ.
There is no mention about this.
ಇಲ್ಲ ಅವ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
Now, how is this court supposed to know? Then it is restricted only to 3.
Only 3.
ಅಲ್ಲ ಹೆಂಗೆ? How is this court going to assume that it is only 3?
Both of us do admit.
But there should be something on record, right?
Page 2, the running in page 147. ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, the complainant is the union which has exposed the cause, and one Mahadevappa, yes, his matter is settled. Then Koragappa is settled, Yogananda's matter is settled.
Where do you say it is settled? How is it now that senior counsel mentioned it is settled? You said it is not settled.
No, ಇದು ಇವರಿಬ್ಬರದ್ದು ಆಗಿದೆ ಅಂತ ನಾನು.
Mahadeva, where is it? Where do you find it, Mr. Kuttappa?
Page 147.
Correct, that is there. It says the complainant is the union and one TB Mahadeva and GN Yogananda, Kargappa Pujari are the members of the union working with the management as operators. Apart from this, they have no exposure. And what is that next? Where do you find that these petitions?
Umesh and Muniyappa, Venkateswar, Gopalakrishna, next paragraph. Avuride. Avaralla, Venkateswappa is working. Venkateswar is working now. Umesh matter is settled in the Supreme Court. Milord, may I make one submission, Milord?
Yes.
There were some cases where we have taken action for not reporting in transfer places and filed 33 2B applications.
Against which workers?
Umesh and others.
Against TB Mahadeva, then GM Yogananda.
Otherly, the applications were withdrawn because dispute was raised. Then the technical problem of Jaipur Jilla apply ಮಾಡಿ ನೀವು ಮಾಡಿ ತಪ್ಪು ಅಂತ ಹೇಳಿ ಒಂದು 6 ಲಕ್ಷ ರೂಪಾಯಿ ಕಾಂಪನ್ಸೇಷನ್
7.5
ಅದು ಉಮೇಶ್ ಕೇಸಲ್ಲಿ that went up to Supreme Court. It was
sir, that's a factual thing. Umesh ಕೇಸಲ್ಲಿ, sorry sir, with due respect to you, Umesh ಕೇಸಲ್ಲಿ 6 lakhs ಸೆಟ್ಲ್ ಆಯ್ತು.
ಹೌದು.
ಮತ್ತೆ ಯೋಗಾನಂದ and other one, I think it's settled for 7.5 lakhs.
Bipartite settlement ಆಯ್ತು because I'm not saying no. Here they were all dismissed.
There was one person left. Who is left now?
Now 3 are left.
There were total 7, right?
Out of the 7, only 3 are left.
What happened? Gopal Krishna.
Settled.
So Umesh, Mahadeva, GM Yoganand and Gopal Krishna have settled.
Settled it.
So the dispute
Pujari, Muniyappa and Desai.
ಮೂರೇ ಇರೋದು.
Kargappa, Ramesh and Muniyappa.
ಹೌದು.
Record your statement that the dispute pertains only to Kargappa, Ramesh.
Yes.
And that too before the labor court also it was restricted or only before this court?
Allo, labor court more restricted to 3 of employees.
The workmen of PAPE, State Employees Union are before this court, assailing the legality and correctness of the order bar award dated 20th April 2010 in complaint number 1 of 1996 connected with PA number, the complaint number 1 of 1998 in reference 27 of 1996 on the file of the Principal Labor Court, Bangalore, herein referred to as Labor Court for dismissing the complaint applications. Complaint filed under section 33A of the Industrial Dispute Act 1947, bracket ID Act falls out. Complaint came to be filed. Next, complaint came to be filed under section 33A of the ID Act in respect of 7 employees by the 7 employees, namely T.B. Mahadeva, G.N. Yogananda, K. Koragappa Pujari, A.A. R.A. G.A.P.P.A. Koragappa Pujari, H.K. Umesh, H. Muniappa, H. Venkateshachar, and Gopala Krishna. The dispute continued. The complaint was continued by Koragappa Pujari, Ramesh Desai, and Muniappa. Koragappa Pujari, Muniappa, H. Muniappa. And in respect of the other complainants, the dispute appears to have been settled. The originally complaint was filed by the union in respect of the 7 employees under section 33A of the ID Act, contending that the transfer of the employees to the different places is on account of victimization, and the transfer orders are nullified, when several charter of demands were pending in reference 27 of 1996. The employees who were acting members of the trade union have been transferred. The management filed counter inter alia contending that the complaint does not indicate or disclose as to how there has been contravention of section 33 of the ID Act, warranting filing of complaint under section 33A of the ID Act. The transfer being conditions of service, the complainant cannot allege that if the conditions of service is enforced, it amounts to change in the condition of service, that the certified standing orders provides for transfer by clause number 12, and the company is justified in affecting the transfer. Further, that every year the employees are shuffled among various departments, so that they can gain experience in the business pursuits. And the allegation of unfair labor practice and victimization raised by the complainant is to give color to the transfer. Before the labor court, the complainant examined the vice president of the union as AW1, and the employees were examined as CW2 to CW5. And in support of their contention, Exhibit A1 to A was marked. The management examined the manager personnel as RW1 and marked documents at Exhibit R1 to R40. The labor court, by the impugned order award, impugned order held that the complainant that the complainant failed to prove that by affecting their transfer, the transfers, the management has changed their service condition under section 33 of the ID Act. That the complainant failed to prove their grievances under section 33A needs any consideration. And that there is no victimization and change of service conditions in light of the transfers. And by the impugned order, dismissed the applications, dismissed the complaint filed by the petitioner under section 33A of the ID Act. Learned counsel appearing for the petitioner would contend that the standing orders and the appointment orders of the petitioners are in conflict with each other. Next. That the labor court has not appreciated the fact that there is a change in service condition of the employees during the pendency of the reference 27 of 1996. And the labor court has not taken into consideration the points which was canvassed by the petitioner. That the transfer as well as the nature of work, taking the court to the appointment orders at annexure. Taking this court to the annexure B to B. B, D, F, contain that the transfer as well as the nature of work is as stated in the transfer order is totally different, and the very transfer is illegal. As the employees are not trained to do any work except the assembling, and the transferred place in respect of the workman, they are required to do a totally different work and asked to perform the work which is very different from one which they have been doing at present at the Dodballapur plant. We're doing at Dodballapur plant, and that there is a change in service condition. the transfer is illegal because the employer is different to where they are transferred. And the place where they are asked to work, is a different independent employer. And it is not permissible to transfer the employees to different employer. That the standing order, more particularly at clause number 12, is not being properly interpreted by the labor court while dismissing the application filed by the petitioner. For contra, the learned counsel, senior counsel, A. Kasturi, appearing for the respondent, would contend that that the complainant, the complaint is the complaint does not disclose as to how there has been a contravention of section 33 of the Act, warranting the filing of the complaint under section 33A of the ID Act. 2. Violation of conditions of service is a precondition to file an application, to file a complaint under section 33A of the ID Act, which is totally absent in the present facts. Taking to the cross-examination of of WW1, then the senior counsel submits that the workman has categorically admitted that there was a cordial relation of the employees with that of the management, and the transfer was not reported by the workman, by the employees. The learned counsel submits that the certified standing orders next paragraph, point. That these senior counsel that the certified standing orders provide for transfer by clause 12 of the certified standing orders, and the company was justified in effecting the transfers as per and taking the court to the confirmation orders issued to each individual employees, which provides a clause on transfer and their services are liable to transfer to any place within India where the company may have his business interest either directly or indirectly. And the employees have accepted the order of transfer. Then the senior counsel, in support of his contention, has placed reliance on the following decisions. Which is that Cipla's case, which is that?
Yes, Cipla's, Vijay, well, Cipla's case, Milord.
Cipla Limited versus Jay Kumar and another, 1999, Part 1, SSC, page 300. And which is the another judgment? That's the only main or any other judgment you want?
Lord, I cited, I relied on Binni, Buckingham Carnatic Mills, 63, 2 LLG 638, saying that there is no overt act of termination. It is only a transfer, and therefore the complaint is not maintainable. In fact, my lord, the authorities
Which is the
Yes,
judgment you have relied upon that judgment by filing separate memo?
yes, my lord, on 2/11/2018,
Don't be that, we should not take all along, which is important actually.
Gujarat Electricity Board,
Try that, other bit, sir, which is that you are saying? another?
2/11/2018, my lord, is the list of authorities.
2/11.
First case is Gujarat Electricity Board, where they said if you refuse to go on transfer, the punishment can be dismissal also. That is the first judgment.
Is
Then Cipla, 1999, 1 SCC 300.
for relying upon this Gujarat Electricity Board
Yeah,
as
that
well.
is, they say, if you don't obey an order of transfer, the only punishment that be given is dismissal. Here, I have not dismissed. They have been reminded. They never reported.
Gujarat
That's what
Electricity
evidence says.
versus Anantram, Atmaram, Sungamul, Kosani. Volume FJR, volume 75, page number 83. You are relying upon that syndicate bank as well?
Yes, yes, my lord.
Syndicate
Cipla.
bank and syndicate, Cipla we have taken. Syndicate bank and Sundar K. Paniadi and another.
Yes.
Paniadi and another 1991 part 1 LLN, page number 358. Yes. Which is the judgment you are relying, Mr. Subra or Mr.
I am relying on AR 2008 Supreme Court, page 336. Then another
Which is that party's name?
Party's name is Tarun Chatterjee. Sorry. DCPP Mazdoor Sangh and another versus NTPC and others.
Okay.
Then I'm relying on Kundan Sugars.
Kundan Sugars.
Yeah.
Kundan Sugars.
Kundan Sugars is
where do you get it in your list of citations?
Third judgment.
Yeah, third is DK Yadav.
Allah, ಇದು ಆಗ್ಬಿಟ್ರೆ next one. Next latest one I filed.
Latest.
Yeah. That's Kundan Sugar Mills versus Ziauddin and others.
When did you file this, Mr. Kutappa?
My lords, I filed it on the 19th August 2024.
You just give that judgment. Judgment, which is that Kundan. Now you are relying upon this.
Both Kundan Sugars, Sugar Mill.
Support of his contention and then consideration. DCPP, Mazdoor, Sangha and another versus NTPC and others. AIR 2008 SC 3396. And then in another
Kundan Sugars Limited.
Kundan Sugars
Mills
versus
Ziauddin and others. Ziauddin and others.
Ziauddin and others reported in.
I don't have the citation, but it's civil appeal number 136 of 1958. Decided on.
I'll give the citation to your lordship.
You just give that judgment.
I'll give the citation.
The court has carefully considered the right contentions urged by the defendant for the parties and having heard the only point that arises for consideration is whether the impugned order award, the impugned order passed by the labor court
1960 1 LLJ 266. 1960 1 LLJ 266. Kundan Sugar Mills was Ziauddin.
The point that arises for consideration is whether the impugned order or award dated 24/2000 impugned award on the passed by the labor court warrants any interference in the present facts and circumstances of it. The complainant contended that the transfer effected by the management is in contravention of section 33 of the Act, warranting them to file a complaint under section 33A of the ID Act. The management contended that the complaint does not disclose as to how there has been a contravention of section 33 of the ID Act, warranting them to file a complaint under section 33A of the ID Act. The transfer is a conditions of service, condition of service. The specific ground urged by the management was that the tractor division of PAFE was established to cater the needs of the farmers in the Karnataka region. And the dealers in Karnataka to whom the tractors are supplied to the farmers had been representing that farmers who come for procurement of tractors wanted the factory trained employees should be placed at the dealer's point to explain and convince the farmers about the silent features of that are distinct for PAFE tractors B. Only by placing a factory trained employee at the dealer's place, the farmers can understand the quality, the service of tractors, and etc. And the competitors are similarly placed company trained employees at the dealer's point. And the competitors have similarly placed company trained employees at the dealer's point. C. Only the factory trained company employee can be effectively be able to impress the prospective customers about the quality of the tractors, and he would be able to attend any minor defects or report to the company effectively about the customer's needs. And in light of the pressure from the dealers, and in the present day competitive environment, the company keeping in mind the overall interest of all, had agreed to the wishes of the dealers. And after deliberation, they decided to move some of the employees to the service center to assist the dealers. The standing orders, the certified standing orders provide for transfer. And as per clause 12 of the certified standing orders, which reads as under page 27 of the objections. Lost by stagnant. Which reads as yes. The confirmation order was issued to each individual to provide to each individual providing a clause on transfer which indicates as under your services are liable to transfer to any place within India where this company may have business interest either directly or indirectly, and you will have to abide by the standing orders and bar or other rules and regulations of the company in force from time to time. The confirmation order was accepted by the employees. The employees have accepted the order of transfer and have been working at several places in the state. The respondent, in light of the exigency of work, transferred some of the employees. The reference 27 of 1996 was pending pertaining to the charter of demands raised by the union. The workmen who were transferred in light of the exigency stated did not report to work at the transfer. The transfer is a transfer of employee from one place to another is an incident of service. And a condition of service, and the employee has no choice in this matter. The nature of work done by the employees in the respondent in the company and the work to be done in the transferred place is identical, meeting in light of the meeting demands of the customers regarding the tractor, and thus the contention of the petitioner that the nature of work is totally different to the place of transfer is unacceptable. In light of the transfer being an incidence of service as stated above, the salary and other benefits remain the same even at the transfer place, and the question of change in service condition would not arise. Section 33. Section 33A provides for a relief to the aggrieved workman, considering them to be a dispute referred to or pending adjudication in accordance with the provisions of the Act. The condition is violation of condition of service. In the instant case, the clause in the offer, in the confirmation order is to the effect that the workman is liable to transfer to any place within India where this company may have business interest either directly or indirectly. And the workman or employee had to abide by the standing orders and the rules and regulations of the company in force. The confirmation order is not in conflict with the general terms of transfer as stipulated in clause 12 in the standing orders. And which mentioned about transfer from one establishment to another, and such transfer would not be attracted by the provisions of section 33A of IDI.
No, they were even being paid incentive, Lord. At page at page 298, 141 of the petition paper book, the witness has said they are being paid even incentive at the transfer place, factory incentive. Page 141. Further examination in chief of by Sri JPK for respondent 2/1/2009. Today I am producing copy of award in 146 of the 8 is marked as 14. I am also producing 5 incentive slips given to transferred employees. Those are the incentives paid in the factory is also paid, even though he's not in the factory.
The cross-examination, further examination, no?
How?
Examination of who is it? WW?
Habu anta.
Of
MW.
Jagdish
He's a
manager.
RW1 Miller.
Manager person would indicate that in his examination sheet, he has produced exhibit R14 to indicate that about the incentives being given to the transferred employee, which is marked at exhibit R15 to R19 and 20 to 24. Is a relevant portion of the order we mark. The apex court in the case of Cipla in identical circumstances as held at para number 12 as under. The in Cipla's case, bracket, Cipla's and the apex court in the Cipla's case has observed that the provision for transfer as contained in the letter of appointment was not in conflict with that contained in the standing orders, and inter-establishment transfer of such employee held not violative of the standing orders, and employees complaint under section 30A of the ID Act complaining against such transfer was dismissed and held that the transfer of employee was valid and there was no alteration in the service conditions as alleged by the complainant.
Clause 12 says if they disobey the transfer, then an inquiry should be proceeded with.
Now they have not dismissed you from service. Their application has been rejected, right? If it was a dismissal, then it was correct. Inquiry has to be done. This is not a case of where an order of dismissal is there. In the instant case, the learned counsel for the petitioner will take your contention on record that inquiry is not been held.
I may be permitted to join duty. That's an alternative now.
After 29 years, he would have joined duty as soon as this order was passed.
If the transfer order is
protest, he would have joined
For
or
the
taken order from this court.
submits that as per clause 12 of the standing orders, the inquiry has to be conducted if the employee has refused to go on such transfer. Learned senior counsel appearing for the petitioner submits that as per clause 12 of the standing orders, refusal on part of the employee to go on transfer will be treated as a misconduct, and the management will proceed against the employees accordingly by holding an inquiry.
Page 138 may be seen, my lord. We have specifically said we have been sending reminders to report. They did not. Para 6, page 138 of Habu's affidavit.
Eventually, there should be an inquiry.
That we'll see about it.
Inquiry when for dismissal against the employees accordingly by holding. The employees, the pre-work employees have not joined the place of transfer, and it has been 29 years. The standing orders and the appointment orders clearly indicate that the management clearly indicate the effecting of transfer. The labor code by the impugned order has rightly held that there is no contravention of section 33 and alteration of any conditions of service applicable to the workman for the workman to file an application under section 33A of the ID Act. And the allegation of change in service condition under transfer is without any justification. For the foregoing reasons, the point
may-
is answered in against the petitioner, warranting no interference passed by the labor court, and this court passed the following order.
Lord, may I make one submission, Lord?
Yes, sir.
If in Lordship's pleasure, that, my Lord, now after 29 years, they are not reported, shows either they are gainfully employed or they are not interested in employment. Things have changed. And now, if they come back to work, I have to again issue a show cause notice, conduct an inquiry, and whatever decision I take, again, a dispute will follow. May I suggest, as an order of the court without forming a precedent, your Lordship may say, your Lordship is ordering some compensation so that matter can end here. Otherwise, my Lord, again we will be going on gallivanting in courts.
What is the compensation which you have paid for the other workers? You have said
They were all dismissed, and there was a technical defect.
Sir, sorry to intervene.
And Jaipur Jilla
6 lakhs. Sorry, sir, sorry. 6 lakhs to a set of
I will
employees.
not mislead the court, don't worry.
No, that you will never do that. 7.5 lakhs. 7.5 lakhs to.
Umesh was paid 6 lakhs as per the division judgment of this court in W writ appeal number 621 to 622 of 2012.
Was that writ appeal number?
Writ appeal number 621 of 2012, connected with writ appeal 1422 of 2012. That matter went to Supreme Court. Supreme Court did not interfere because there was violation of 33(2)(b) according to Jaipur Jilla case, and therefore I was asked to pay. Here, they are all dismissed. Here, there is no dismissal. These employees have not reported even after the judgment of the tribunal, saying your application is not, there is no violation of condition of service. They could have reported with under protest and contest, or take an order from this court. I will subject to the result of that petition. I will go and report. And then asked me to come back. I would have done complied with it. For 29 years, they have not reported. Therefore, my submission to you is, Lord, your Lordship may order some small compensation and close the matter here itself, so that I also don't have any problem. He also, my learned friend also will not have any problem with regard to contesting again one more dispute after they are some
Now
discrimination.
that charter of demands is already pending before the labor court.
So similarly placed employees who are transferred, they are paid 7.5 lakhs because their services came to be dismissed. 7.5.
Violation is the part.
And in the case of Umesh, sir contested, I also argued that matter. My senior argued 6 lakhs compensation.
Otherwise, there was a violation of 33(2)(b).
How much is appropriate, senior counsel and Mr. Kuttappa? How much is appropriate?
I leave it to the court.
We leave it to the court. Your Lordship may say,
we will not.
Case, under 226, your Lordship is exercising jurisdiction to order some compensation. And I suggest the same compensation paid others may not be ordered because they were dismissed and there was found that I violated.
Petitioners are in a better position. They are not yet dismissed, so they'll be entitled for more compensation. They're not yet dismissed. Their chances of reinstatement are still there.
No, I will take disciplinary action.
And now, not yet taken,
absenting for so many years.
So they are in a better position.
They could have taken orders from this court to report. They did not.
Yes. Both of you will suggest one figure. We will arrive at one figure then. You suggest one figure.
I suggest your Lordship may order about 2.5 lakhs to 3 lakhs.
Bada. Might as well I take an order from the hands of this.
Mr. Kuttappa, how much you say?
It's given, my lords, it's given 7.5 lakhs and 6 lakhs. How can I be discriminated?
What discrimination? You are not. Discrimination agudilla. They are not similar.
Senior counsel, now in this petition, the workmen are in a better position than in the workmen who were given 7,50,000 and 6 lakh because
we do not know. Suppose I dismiss them now. They had to go to the court again, contest the matter. For absence of 29 years, they could have taken an interim order from this court. I will report to duty without prejudice my contention, or they have done now nothing. No
You
interim
pay,
application was
6
filed.
lakhs, Mr. Senior Counsel, pay 6 lakhs. 6 lakhs.
My lord, I so 6 lakhs will be too much, my lord. I am sorry, your lordship
No, I can also come.
may not
Let it
enter
come
into
as
that
an
aspect
order.
at all.
That
Let
is
both of
come as
us
an-
fight the case out, because that will be too much, my lord.
ಇಲ್ಲ,
We
ಇಲ್ಲ,
will pass
let
an
us-
order. You can convince your management.
My lord, I am not able to convince my management. Your lordship may say it's the order of the court. I would
Yes, yes,
suggest,
order.
my lord, kindly do not do this because I will, this is very unfair on my management's part to say this. Those cases where people were dismissed from service for on violation of
both
33(2)(b).
Mr. Senior
In
Counsel,
violation of 33(2)(b), that is the finding.
have already
So I
dismissed
do not
the.
agree with that. But to give them this much of compensation for not reporting for duty, my lord, it will shock the conscience of any person. My lord, please do not do that. I beg of you to consider some compensation, but not so much.
Yes. You both of will come to a consensus as to how much amount this court has to order, and we'll pass over the matter. Yes.
ಇಲ್ಲ,
We have already
ಇವತ್ತು
passed an order of.
ಅದಲ್ಲ ಇವತ್ತು ನಾವು
No, there is an already order passed by this court. Only as a way of compensation, what you would be entitled.
ಅಲ್ಲ, we leave it to the court, but not that 2.5 lakhs. What is being paid to Umesh could be given.
Umesh has paid how much? 6 lakhs, right?
6 lakhs.
6 lakhs is too much, my lord. Kindly appreciate. Is it
And
fair?
let it come
Is
as
it
an
fair
order
to
of this
order
order.
6 lakhs or rupees for a person?
The management is
who does
very
not report for work for
contested complaint.
29 years. For
Let it come as
29
an
years, they
order of
don't
this
report.
honorable.
Yes, yes.
Last, warranting no interference passed by the Labour Court, and this court passed the following order.
His ID was also closed, right? The reference.
Yeah, my lord, all settled. All settled.
Only 3 matters are pending.
Looking into the present facts and the settlement arrived in respect of the other workmen who have been dismissed from service, namely Umesh Mahadeva and G.M. Yoganand, wherein the matter and Gopal Krishna, wherein the matter has been settled by paying compensation from rupees 6 lakh to 7,50,000.
7.5.
7.5. That is 7,50,000.
Yes.
In light
My lord,
of
may I suggest, please do not order that kind of money, my lord. That will unnecessarily put me to a problem, because this will be very, very unfair. Kindly consider something between. I would suggest, my lord, may I make one suggestion, my lord? Make it about 3.5 lakhs, my lord. I don't mind.
No, we'll certainly
Let him contest. If he wants to contest, let it be order of the court. He can't threaten the court.
No.
Then
Sir,
please
sir.
do not pass it any order, my lord,
If
on the question of compensation.
Sir, if
Your
you
lordship
could
may leave it
intervene,
at that.
I got a right to
intervene.
intervene. Request this honorable court. What is paid
go
to?
and challenge you. If you want any compensation, now we will not order anything then in this. If both
Very
of you
well,
are
your
not
lordship,
in
your lordship will
consensus,
leave it at
that
that.
was the
We will
reason
fight
this
it
court
out.
adjourned this matter. Is it not? The court adjourned this matter to see whether you could have settled the
Yes,
matter.
my
Give some-
point is very adamant.
Yeah,
They are not willing, for having been absent for so many years, they want so much of money.
So we are
No,
not
this will set
asking
a
for
precedent for
we are not.
everybody.
We are not
It's not
asking
one
petition
case.
of lakhs.
It will be order of the
We
court of
are
the High
asking
Court,
only.
a constitutional court.
the order of transfer, which is around for more than 29 years. However, looking into the similar facts and circumstances, this court feels it appropriate to award a compensation of rupees 5 lakh. In this court, pass the following order. This petition is disposed of. The impugned order passed by the Labour Court stands confirmed.
Well, can it be made 4 lakhs? I
5
will
lakh.
be able to convince the management so that we
ಇಲ್ಲ
don't
ಇಲ್ಲ ಇಲ್ಲ
appeal.
ಬೇಡ ಬೇಡ ಸ್ವಾಮಿ.
So that ಬೇಡ ಬೇಡ ಅಲ್ಲ ನೀವು ಬೇಡ
How
ಬೇಡ
much
ಅಂದ್ರೆ
time,
ಏನರ್ಥ?
Mr. Senior Counsel, how
I'm
much time?
asking the court.
Mr. Kasturi sir, how much time you want to pay that amount?
My lord, kindly make it 4 lakhs. My lord, I can
ಇಲ್ಲ
pay
ಬೇಡ
it
ಬೇಡ
immediately.
ದಯವಿಟ್ಟು ಬೇಡ.
I'll convince them to pay it. But
ಇಲ್ಲ
if your
ಬೇಡ
lordship
ದಯವಿಟ್ಟು
orders
ಬೇಡ.
5 lakhs, my lord, it will be too much, my lord.
Yes.
Kindly make it 4
No,
lakhs.
there
I'll
was.
pay it within 1 week.
In fact, I'm breaking the news. It was sir has agreed to pay 5 lakh long back in this
You did not take it, sir.
Yes, sir.
in this matter.
Kasturi sir,
You
Kasturi
did not
sir,
take it.
please, 5 lakhs to be paid within period of 8 weeks. 5 lakhs each to the 3 workers, namely Koragappa Pujari, Ramesh Desai, and Muniappa, within period of 8 weeks. Yes.
My lord,
Yes, please.
may make one, sir. Kindly bear with me for 1 minute, my lord. Kindly, my lord, make it at least 4 lakhs, 4.5 lakhs. I'll be able to convince so that I don't appeal against
ದಯವಿಟ್ಟು
the
ಬೇಡ ಸ್ವಾಮಿ. No, let it come
Senior
as an
Counsel, you
order.
said so much. We have also agreed. 6 lakhs we have reduced to 5 lakhs. Let it be 5 lakhs. Yes.
Much obliged.
With respect to you, sir.
But without bombing a precedent, your lordship will say.
Yes, of course. This. No matter.
Because they will cite your lordship has given 5 lakhs for absenting.
Others and all 7 lakh 50 and 6 lakh. What to do now?
Otherly, disciplinary action ಆಗಿದೆ.
This order is being passed in peculiar facts and circumstances of this case.
Much obliged. Without forming fact precedent.
That is a.
Much obliged.
Yes, 2:30 matter. It's already 4 o'clock.
Okay.
Case. Just 1 or 2 paragraphs.
What is that order under challenge? Just for the.
Government is challenging. Passed by the Industrial Tribunal.
Yeah.
Lord, the page 152. Rejecting the application filed by the petitioner under section 33 that petition is not maintainable under 33 but it should have been under 33(1)(b).
Both the 33(1)(b) and 33(2)(b) are one and the same, or is it?
They are 2 different. They arise in 2 different circumstances. That is point. 33 if you want to say is 1B. 33(1). During the pendency of any cancellation proceeding before a cancellation order or a board or a proceeding in respect of a registration, no employer shall be for any misconduct connected with the dispute.
It has to be connected with the dispute.
Yes, connected with the dispute, discharge or punishment in such dispute, save with the express permission in writing of the authority. 1B. If a dispute is pending before a tribunal order, then if the misconduct for which punishment of discharge or dismissal is sought to be imposed by the employer, if that dispute is connected with the dispute which is pending before the court, then it can be done only with prior permission. Same with express permission.
Yes.
With express permission. Now, 33(2)(b) is identical with 33(2). During the pendency of any such proceeding before the law, then please come to B. 33(2)(b) for any misconduct which is not connected. So, not connected to the dispute. Discharge or punish whether they have dismissal or discharge, provided that no such workman shall be dismissed unless he has been paid monthly. And an application has been made by the employer to the authority before this proceeding is pending
for approval, yes. Therefore, this is post facto approval. After approval, it relates back to the date on which punishment has been. And in respect of 33(1)(b), it is prior permission to dismiss an employee from today. But then even if it takes 5 years later on, or once the permission is granted, it relates back to the original date on which the employer has proposed to impose the punishment. Now, in both these matters, the law of the land is, whether it is under 33, section 33(1)(b), and then there is one more 33, 3. B also may kindly listen. 33(3) pertains to protected work. There are some union employees who are declared as protected work. Action is to be taken in respect of the protected. Then 33(3)(b) would apply. That is again like 1(b). 3(b) is prior permission before imposing the punishment. These are the 3 provisions. Now, the procedure that is required to be followed by both in respect of section 10, dispute, and in respect of section 33, whether 1(b), 2(b), or 3(b), is that if the order of punishment is decided by an inquiry, then preliminary issue regarding domestic inquiry which has been read as same, and the tribunal will have to give a finding on that. If the inquiry is held to be fair and proper, then the court in section 10 the procedure is different, because after the introduction of 11A, additional powers have been granted to a tribunal while adjudicating a dispute under section 33 under section 10. 11A consists of 2 aspects. One is reassessing the evidence in the inquiry for a limited to find out whether the finding is correct. And the second part is with regard to the proposed action. These 2 aspects are absent in respect of a matter under 33. Therefore, the courts are held that if it's a matter under 33, the scope of interference is limited.
Summary proceedings.
Once inquiry is held to be fair and proper, the question of reappreciation would not arise. It is only under 2 circumstances that the court can interfere with the order of punishment and refuse to grant either permission or approval. When it finds that there is absolutely no evidence at all, or if the evidence that is there, if the inquiry officer has relied upon extraneous material which is not part of the inquiry to record everything. That is one. And secondly, if the punishment is on account of victimization, that is, the victimization is if the employee is a very active trade union leader or not. And because of his trade union activities, the employer wants to punish him. And if the court records the finding of fact that this, in fact, though it is styled as misconduct, it is actually not a misconduct because no charges. And therefore it amounts to victimization. So that circumstance that the court can refuse. Otherwise, once the inquiry is held, the scope of interference is what has to grant approval or permission. And this would not be final. This is only a limited purpose action, that the bar which is there is lifted so that the employee goes out, but then the order of punishment does not become final because either approval is granted or permission. He has a right to, employee has a right to raise a dispute on section and both examine the entire issue regarding discrimination, reassessment of evidence, proposed punishment. These are all aspects which can be adjudicated only at section 10.
But once an application under 33(2)(b) is been rejected,
yes,
then the order of dismissal is doesn't get confirmed.
Order of termination becomes non-existent. As though there is
no dismissal.
Yes,
no termination.
that is in view of the judgment of High Court. But Jaipur Jilla said we are not concerned with it right now, it will not apply. Unless because the court rejects my petition. Then of course you will be deemed to be in service, I may have to consider in service in any order. My endeavor is to point out that the rejection of the application seeking approval is not justified for two reasons. The first reason is that the finding of the tribunal that it ought to have been filed under 33(1)(b) and not under 33(2)(b) is misconceived and not supported by either facts or law. Number two, even if it is to be assumed that the charge sheet in respect of which the order of punishment has been imposed is, if it is to be held to be connected with the dispute, I am only arguing I am not admitting it, I am only saying, if the court comes to a conclusion, as the tribunal has come to a conclusion that it is the misconduct for which they have imposed the punishment is connected with the dispute which is pending, and therefore it ought to be under 33(b). My proposed submission to your that this is a composite punishment not in respect of one charge sheet, but there are two charge sheets. There are two charge sheets. Even if one, without prejudice, if it is to be taken into consideration to say that it is corrected. Now, the other charge sheet, the allegations admittedly are not correct, but the tribunal has not got the conclusion that it is corrected. Therefore, two options are there. When the act gives me two options, either to file I can in respect of the other charge sheet, because this is a composite punishment. In respect of two charge sheets, I can either file under 33(1)(b) or under 33(2)(b). The act does not make it mandatory that if the composite punishment is in respect of two charge sheets and if both options are there, then 33(1)(b) proceeds over 33(2)(b) and the principle of doctrine of election would come into force, and therefore my responsibility is, my option is that the labor court or the tribunal ought not to have rejected by approval application, because approval application is also maintainable in view of the other charge. In fact, I don't admit that the charge sheet in respect of which the tribunal has said that it is connected, even that is not connected with why? Now, the judgment in Mysore Lamb's case, I just
yes.
Well, I read. Okay. Please see, at page 808. The provision that developed from the court decisions of this project. Page 808.
808? Yes.
The provision that emerges from the above quoted decisions of this court, they stated that in a proceeding under 33(2)(b) again, the jurisdiction of the investment judgment is applied to. Now, 33(2)(b) because in this case it is 33. Whether 33(2)(b) or 1(b), it is the same. Whether a proper domestic inquiry in accordance with the relevant rules, standing orders, and whether a prima facie case for the based on legal evidence is made, whether an employer had come to a bona fide conclusion that he and did not amount to unfair and was not intended to victimize the employee regarding questions settled by decision of this court, then will not weigh down the marked portion if our domestic inquiry suffers from any defect or infirmity. The labor court will have to find out on its own assessment of them, because if inquiry set aside again, parties will have to give the process. It will go and then find out again and grant approval. Ultimately, if it comes to charges to anybody. Then we want kindly come to the powers below the 810 have taken this law.
Yes, yes.
If it is a valid domestic inquiry,
Yes.
if it is valid to examine further as to whether primary then we will come to page 812 on the right hand side. Thus, it may be seen, though practically there is no difference between the scope and nature of the inquiry to be made by the director of the 10 PC under 10 of the Act and in a proceeding under 33. 33 is either 1B, 2B, or 3B. The Act in a dispute relating to imposition of penalty of removal or dismissal. They have additional powers in respect of two matters. Namely, not this is in respect of Section 10 adjudication.
Yes.
Additional powers are to reappreciate evidence in domestic inquiry is valid, and the power to substitute other penalty by way of lesser penalty in finding recorded. This is the scope under Section 10, but not under 30. While adjudicating a reference in view of 11A of the Act, and they do not have them in a proceeding under Section 3.
Yes.
Yes. Now, Para 13. The question arising for consideration in these cases has to be considered bearing in mind the above difference in powers under 33 and the individual right of the remedy intended to be conferred against the order imposed against him by incorporating the elimination. Then we got Para 16 will have the scope of 33 there.
Yes.
And then para 17, what is the additional power given to a labor court or a tribunal under 11 while adjudicating a dispute? Then ultimately, Milord,
What happened to the further directions of this bill? Nothing has happened. 33. To
yes.
give a reference, to treat this application as a reference under section 10
Yes,
of
that will not, in view of Jaipur Jilla, everything has come back to square one. Jaipur Jilla says they have reversed the Punjab beverages which have the field of law, which is in fact a contradiction to the statutory provision. That's the law.
Now, what has the labor court done now in the order?
Yes, therefore, we got para 25 and 26 in the
Yes.
In the light of the above discussion, I am inclined to take the view in all cases concerning dispute related to imposition of penalties or removal with prior permission or subsequent approval through an order made by the labor court. Though it does not constitute different cases, or according to that. Here, or federal by something like that. The approval accorded and so after accruing validity the final report constitutes no valid basis not to refer. Well, after approval or permission, it is open to the employee to get a matter record and then report. And then they have said 33 to be para 27 and yes, now charge sheet 11/11 to 1999 will also to get it. But
When we got to our notice, then we only making after the allegations in the board charge. But the law is not there.
Yes.
I will not go in detail, but I will only take this.
Yes.
First charge sheet connection, page 51, 11, that is got to our notice that on 9/11/99, and you are asking me to check for the machine. We left your machine. This is found missing. From about 20. Then I just tried to trace your error, but he could not trace you anywhere. Whereas at least you came to your workplace to rejoin duty at about 3:30. You rather than waiting for without permission. So you are engaged on a work on a continuous nature about whereas on your return to your workplace, when the shift in charge asked your whereabouts, you shouted against him in order of giving insolent replies and telling him by saying, your false replies that you were near the machine only and insolent behavior telling him superior. Leaving the workspace, not being there, especially when you are required to work while on the machine, it's dereliction of duty. Then the second task, section B 252. This is 9/11/99. This incident is on 7th March.
Yes.
You were on duty in the first shift from 6 a.m. to 2 p.m. on 7th March. On that day, you are assigned to work on 223 machine located in the main hall. While you were on duty at about 1 p.m., then the first shift in charge, Mr. K.C. Dinesh, and the secretary officer, Mr. Menon, came to the main hall to disburse the factory month wages, to disburse the February month wages to work, and started calling the employees to their table to receive the wages. You suddenly stopped your work in 223 machine and left your workplace and went running towards the shift in charge table along with Mr. Nikaraj, Mr. Bhimraj, incited the other workers not to take the wages as stating Yaru payment for meeting. Again, you repeatedly told the workers not to take payments. After the close of the first shift at 2 p.m. on 7th March, you should have gone out of the premises. Instead, you led the first shift workers along with Nikaraj and Bhimraj and made them squat inside the main gate, blocking the movement of. While squatting inside the main gate, you refused to leave the factory premises when the management, by its memo directed the workers to leave. And then you started agitating workmen at about 7:15 p.m. to rush towards the admin building to get out the managing managers there. And you took active part in making the agitating workmen to squat in front of the cabins of the management and to get out. Here, from 10:15 p.m., when the manager production who was on the new admin building along with other managers was going towards toilet room for me. You along with Mr. B. Satyanarayana, Vikraj, Bhimraju, suddenly rushed towards the mercy. You are trying to run away, taking your money, and caught him by his arm and dragged him till the staircase and threatened him that you will put him up. After this incident, the manager production he was made to retreat to his room, was trying to talk to agitating employees and persuading them to see reason and abandon their illegal ground. You stood up and started kicking on the side cabinets and told him that I want to keep you this. Also, you were punching your hands in the air and shouted that I want to give punches like this and break you the job. You, along with other workmen, continued to squat inside the admin building, hurling abuses against managers, shouting slogans, intimidating and threatening. Thereafter, you started inciting the agitating workmen to go to PD room at about 3 a.m. on 8/3/2000 and Ghirao, the vice president, Mr. Biswas, who was sitting in PD room in the first. After seeing that the staircase which leads to the PD room was blocked by manager, Mr. R. J. Prakash, Mr. Gangadhar, Mr. Pandu, the other managers and officers, you started telling the employees to push the manager inside and forth.
In order to encourage them to forcefully move forward, you along with Mr. B. Satyanarayana, and others push the female employees towards the manager so that they are pushed back and give way. In this process, when you attempt to enter the PD room forcefully, you push towards the manager action in a threatening manner. Once the agitating employees made their way to PD room and started sweating,
Conduct under the following clauses of typical standing order. 30.1 to 30.19. They have mentioned the standing order clauses in the next one. How many workmen are involved now? Two?
only one.
Only one. Two charges again. Two charges. What happened to that?
That went against us. But then issues which I have raised here are not raised.
That is again under 33 to be.
They have made that it's under
33 to be is a provision made to the employer that he gets immediate dismissal order gets confirmed, or rather because you need not pay the other benefits to him during. No, 33 to be.
Purpose of 33. Purpose of 33. Because the 33 puts a bar on an employer for taking action against employees under the standing order in respect of certain matters when an industrial dispute of general nature is pending before a labor court or tribunal or a concession.
Otherwise, you would have made a general.
Otherwise, the standing order does not bar an employer from taking action in respect of the misconduct committed by an employee. At any time I can take, because there is a dispute which is pending, I have to follow certain procedure. I have to, if it is connected, I have to file application. Express permission. But if it takes effect from the date in which I want to.
Correct.
And then we got whether that action is justified or not under reassessment of evidence, crime and proposed strategy, that will be gone into a proceeding. 33 is only a bar. If the bar is removed, that is not the end of the matter, they can still go on the procedure. Nothing under 33 to be over. One page missing here.
This is in continuation started starting. There is no continuation.
Starting for misconduct.
That is page 25.
Yes. So therefore, these are the charges. Mainly, what happened in the first shift on 7th March?
Yes.
Instigating the employees not to accept, and when they wanted to go, they were prevented. They were off. And on 8th, what happened on 7th? Yes. Then we got. So, what I would like to impress upon your office here. So, we got here. What happened subsequently?
Subsequent to?
Subsequent to 8th March. Now, what happened ultimately was, they all of them created an issue thereafter. And ultimately, they were forced to declare lockout. And that lockout was referred for adjudication. Whether that can be said to be connected with this is a matter which has to be examined by all. In fact, Lord, at the time when the other issue, in respect of two other persons, then Lord, the latest judgment of the Supreme Court was not there. The Supreme Court in the latest judgment has taken a different view in respect of critical situation. Now, Lord, on this basis, inquiry was held. In the inquiry, charges were held with respect of both. And then we Lord, please see the order of punishment. Order of punishment is annexure C. Page 30. when issued with charge sheet 11/11/1999, you submitted your explanation 15/11/1999. Then Lord, we refer to the report. Thereafter, the inquirer submitted a report and findings dated 5/5/2001, holding you guilty as charged. Then Lord, the second show cause notice dated 23/2002 was issued to you, including a report and findings of the inquiry. You are called upon to submit the explanation, if any, on the report, and you have failed to submit it. Then Lord, we refer to the second. You are further issued with one other charge sheet dated 2/5/2000. Then Lord, ultimately, even here, Lord, paragraph 5. We refer to the report of the inquiry officer holding that the charges are established. Then we got a second show cause notice dated 26/2/2003 issue. Paragraph 6. Then we got paragraph 7. It considers the replies given and then proceeds to hold that the report and findings in paragraph 8 below. I have also gone through the report and findings of both inquiries. The same are based on ruling. Reasons given by the inquiry officer are heard. Thus, I hereby then you are the paragraph 9, the charges proved against you are great. You not only left the workplace and also shouted at the superior and behaved in an indecent manner. You disobeyed the instructions. Further, you went to the extent of insulting and instigating other workmen. You instigated the workmen not to receive wages. You abused the managerial staff and threatened the officers and derogatory officers. You got hold of the arm of production manager and dragged him to the case that would do it. You punched your hands in the air and threatened that you would break the jaw. You continued to hurl abuses and shouting slogans against the manager. You kept under illegal confinement the officers. You did not even allow them to answer. You proved misconduct very serious in the experiment that are tolerated. You indulged in righteous disorderly behavior and engaged in the considering the seriousness of the proof, this standing in all the stuff. Consider to give your actions, then not consider the above, for appropriate punishment for proof this part. Accordingly, the year by discussion, both inquiries opposite punishment. And therefore, we are next, since an industrial is pending adjudication before industrial driving trading 138.
What was the dispute pending?
Yes, I understand. Trading 138 of 2000, in which you are a concerned workman and not concerned dispute. Plus, the distinction is under 33(1)(b), the dispute for which misconduct for which I am imposing the punishment of dismissal must be concerned with that dispute.
You have mentioned that the concerned workman.
Yes, that dispute is a general dispute. It concerns all workmen, including this. We have filed an application before the tribunal today seeking approval. Not well.
Yes.
I think this tomorrow.
Tomorrow.
Today. We have continued till 5, but then.
Yes.
Difficulty is.
Yes.
Ganesha Visarjan today. So, I have to leave it.
Yes. So the counsel for the petitioner for the 2 year for tomorrow we have one matter. We have tomorrow 2:30 already date given. On Saturday, the first hour itself. Saturday at first. Saturday, first hour.
I have a listed matter in my school. Already,
Then 23rd.
I have time to work. I think I saw it.
26th at 2:30. So you can complete your arguments on that day.
Yes.
My lord, may I make one submission, Lord? The previous matter between me and Kuttappa, your lordship may make it as a global compensation so that we will not have any further disputes.
Towards full and final settlement.
Global compensation.
To each of the workmen, that is 5 lakh global compensation.
Yes.
Global compensation.
Much obliged.
Yes. Afterward, afterward. Number 10 now, afterward again, 22. After.
Number 22, which implement effect.
We have taken this matter because it's of the year 2008. What is the issue now? Is it still alive? Is the dispute still alive?
Not alive.
Petitioner number 1 is not alive. The first petition. He's no more. He's no more. So his LRs are there on TS. Particularly 1B. When there is any dispute pending, connected to the dispute. Yes, now we have just heard that. There are only 2 things here, 33 2B, section 10. These are the 2 things here.
33 1B. During the pendency of any conciliation proceeding before a conciliation answer or a vote.
So the first part is common in both 33.2 and 33.1.
A reads that
Alter.
in regard to any matter connected with the dispute. Alter to the prejudice of the workman concerned in such dispute. The conditions of service applicable to them immediately before the commencement of such proceedings or for any misconduct connected with the dispute, discharged or punished. This is important.
So with that connection, if he has been discharged or punished, he cannot. He should be done with the express permission in writing.
Yes. Okay. In the present day, the pending dispute was pertaining to transfer about 22 workmen from one place to the other place, and also regarding payment of bonus. About the dismissal is in relation to a misconduct.
Misconduct is not joining the place of transfer?
It has nothing to do with the transfer issue of loans issue. It after issuing a charge sheet, an inquiry was conducted, and then our service. So complaining violation of this section 33 1B we approach the labor.
That is altering the nature conditions, altering the conditions of service.
Yes. Now the tribunal has said that since the dispute is not connected to the issue involved in the general dispute, no approval is no application, prior application is required.
No prior application, permission is required.
Permission is required.
That is approval.
Yes. So that will not have about the task force.
It is in respect of which petitioners?
Last 2.
That is 22.2 and 22.3.
Yes.
That is pertaining to. Just a minute. What did the labor court hold?
But labor court dismissed our complaint because our remedy was to file a complaint.
So your complaint was 33A, na?
Oh,
This is against the 33A, you are before this court in these two petitions.
against an order passed.
So there is no alteration, transfer and all, that cannot be a alteration to be said. So this has to be dismissed.
These two petitions were about me.
Has to be dismissed. Has no alter or change in the service condition.
Yes. But the tribunal, in the course of its order at page 133, there are some reasons.
133. This is under application under 33A, alva? Yeah, complaint. And what is this other two petitions?
The other two petitions pertain to the tribunal allowing approval application filed by the management under section 33 2B.
So that is apart, and this section 33A is something different. So why was it connected? Because it appears to be from the same person.
Same person and same manager.
The one, if you give one matter to one advocate, he will have all the options of 33, 2B, 33A and everything. Yes. So this has to go. Now we will come to 33, 2B.
Yes. That case not another.
ಸ್ವಲ್ಪ ಕೇಸ ಜಾಸ್ತಿನಾ? Now, under what circumstances this 33 2B application can be allowed? What are the conditions precedent for 33 2B?
The tribunal can go into two aspects. One is whether inquiry is held to be fair and proper.
Once the inquiry is held to be fair and proper, so it is open. Entire inquiry proceedings are open to it.
The next question that needs to be decided by the tribunal is whether 1 month's wages is paid or not.
That is a precondition for 33 to be compliance. If the conditions are fulfilled, assuming it has been fulfilled, only on the condition being fulfilled can the application under 33 to be allowed.
Only those two aspects need to be taken into consideration by the tribunal.
What is the condition or what is the prerequisites for the labor court while considering an application under 33 to be apart from the condition mandatory provisions of compliance?
That is not labor court can certainly go into the validity of the inquiry. If the inquiry is not going to be not fair and proper, then Lord, it can pass an order to that inquiry. In that case, Lord, even if the payment is made, then Lord, since there is a violation of principle of natural justice, labor court can set it not order.
Now the inquiry is held to be fair and proper.
Then Lord, the next question would be whether 1 month's pay is paid or not.
Even that is paid.
Then Lord, of course, there is no further.
Now you have to satisfy
that
these are the conditions which has not been followed by the, or it is not fair and proper.
Yes. But I just
Either 33 to be seeking approval. According to you, they have not paid you 1 month's wage?
No, it is not paid.
That is your main grievance.
Yes, that is my main grievance.
Non-compliance is a must, compliance is a must in under section 33 to be.
So can I just pass on? Regarding the number 12998.
I think only that is relevant, right? Both are similar. Ramchandraya and
Here, Lord, in this 12998, Lord, give us the
date of.
He was working as a clerk.
And the other one?
The other one, he was working as a field supervisor. Yes.
Date of appointment?
But here, 8/8/1988 is the date of appointment as a clerk. Then the date of suspension is 9/2/1994.
And in field supervisor?
That is not the same date.
Same, no? Same. There is no change.
Now here, the charge sheet was issued on 4/4/1994. But I just mentioned very briefly the nature of the charge. That he had obtained sugarcane seeds worth rupees 551925 on 28/2/1993
the factory for planting the lands to an extent of 3 acres in his possession in survey number 341 of Naganapalli village. Here, Lord, even though he was an employee of the management, but what happened was, Lord, his employees, they used to get the sugar cane seeds for being planted in their respective lands. Then that, as per the agreement dated 6/3/1993, Petition had agreed to supply 50 tons of sugar cane to the factory grown in the above lands. That he was issued the permit on 20/12/1996 to grow 50 tons of sugar cane in his land. That he did not supply sugar cane as agreed to supply. However, he supplied 16.340 tons from other sources on others. That he claimed false bills to the tune of rupees 10,188 in the guise of supplying seeds to two farmers as if the same was supplied by the management. That he has claimed the transportation charges of rupees 507 for having supplied the seed to the two farmers in his bullock carts. Lord, these are the precise charges. Now, Lord, thereafter, the inquiry was conducted by one Sri Ramaya, who was an advocate attached to the chambers of ABC Prabhakar, who was an inquiry officer. Then, Lord, on 9/9/1996, after having conducted the inquiry was submitted. I was issued with a pay order for a sum of rupees 3,898 paise 25.
You said that is not paid. That is your salary. This was your salary. Salaries are not on this.
It was paid, but there was a shortfall.
What?
There was a shortfall of
Amount. What was your actual salary?
that I have stated you. Please have a look at it.
So according to you, they had paid you an amount of 3,998, which
Yes.
is not your actual salary.
So I was actually entitled to be paid rupees 4,066. There was a shortfall. Now, please, at this stage, can I just request you?
Yes, yes.
Page 24 of my petition.
Yes.
Your basic wages at page 24.
Yes.
Basic wages rupees 1955. Then dearness allowance rupees 1,705.76 paise. Then HRA 94. Then medical allowance 72 rupees 50 paise. Then BDA. Then total 3961. Then Lord, apart from this, 3 increments were required to be paid at the rate of rupees 35 per year, amounting to rupees 105. So Lord, in all, 4,066 was the amount which I was required to be paid.
How did they calculate this 3,893? How did they calculate?
So they calculated by excluding this medical allowance, HRA, and the 3 increments.
Medical allowance, it is never added. HRA is added, of course.
Yes, sir.
HRA is there. And then if you less this 72 rupees,
yes,
how much will it come to?
So medical allowance, then
No, if you less that medical allowance is usually not added.
No, it should be added. Because wages defined under the definition of wages, all these things are included.
And variance DNS allowance, where is that?
This is not
VDA.
variable DNS allowance.
Variable.
This is also to be added. These 3 items were not added. Then as far as these 3 increments are concerned, one witness says these 3 increments have been calculated. Another witness says these 3 increments have not been calculated.
What does the 332B says? 1 month? 1 month salary, no?
Provided
unless he has been paid wages
for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer.
Where is wages defined?
Now the wages is defined under section 2RR. Wages. Wages means all remuneration capable of being expressed in terms of money, which should, if the terms of employment express or implied, were fulfilled by payable to a workman in respect of employment or of work done in such employment and includes such allowance, including dearness allowance, as the workman is for the time being entitled to. The value of any house accommodation or supply of light, water, medical attendance.
You have this DNS allowance,
Yes,
then house HRA, supply of light, water.
then medical attendance or other amenity.
That is, you have to claim that. You have to claim that, right? You cannot add it as a figure.
So it is, the labor code comes to the conclusion that I am entitled to medical allowance. Because every month I would get this.
Until you have some medical.
But that is medical reimbursement.
Then
This
what
is
is
medical
this?
allowance.
So there is some medical allowance to be paid to the wages.
Yes, but that is the fixed allowance.
So labor code says that medical attendance has to be given.
Has to be given. But the witness says that this is not paid.
Then traveling concession.
Then traveling, of course, that I cannot be entitled to because I did not get the extension. And I never used to travel.
So according to you, this DA, HRA, medical allowance and VDA had to be added.
Yes.
Increment anta ellida?
Increment to,
it's not
I was not paid increment for 3 years. That is during the period of suspension. That was required to be added to the.
I don't think that could be added in the wages. How could that be added?
The annual increment andre, so that will be reckoned while calculating the monthly wage.
Yes,
So every month I would be paid that much of the rate of increment every month. How not so with this grievance I approached to the tribunal. My main contention was not
not paid the 1 month salary wages.
Yes, then the Lord, as regards the validity of inquiry, Lord, I also thought
it was held to be fair and proper.
it was held to be fair and proper. Notwithstanding the fact that Lord, the witnesses examined on behalf of the management Lord had admitted that no documents were furnished to me, and there are several admissions Lord in the evidence. I would like to go through some of these evidences.
Yes.
Lord, can I just request the doctor to kindly turn page 210?
210.
210. This is on the issue of inquiry. Lord, I'll read from the middle of about 11 lines from the top. I did not give the copy of the charge sheet at page 210.
Yes.
Did not give the copy of the charge sheet to the opposite party as the management has already given to the opposite party. I did not give the documents which were marked as exhibits 11, 3, and 7. In the absence of the opposite party, they marked the exhibits 10, 11, 3, and 19 on 1/6/1994. I did not verify whether the management has served the notice of inquiry to the opposite party before marking documents exhibits 10, 11, 12. It's true that some of the Xerox copies as documents in the inquiry proceedings on 1/6/1994. I did not serve the copies of documents on opposite party. I did not serve the list of documents to the opposite party. I did not verify whether opposite party served some documents. Opposite party filed an application to engage an advocate for the settlement process. Same application is marked at exhibit A7. It is true that opposite party filed another application on 7/1994 requesting to give permission to engage Union President as the model standing orders. Same is marked at exhibit A8. I told the opposite party to mention the Union President and accordingly, they mentioned Union President's name as yes form. Then note cross-examination. It is true that I did not follow the provisions of the standing orders by conducting the inquiry. It is is true that though the standing orders provide to assist the opposite party, the union president, even though rejected the application of the opposite party, it is not true to suggest that in order to help the management, I rejected the application of the opposite party. It is true that the management representative is a qualified person. I'll just skip off the next the other part. Then, you know, kindly turn to page 216. But this is the evidence on merit. You can see somewhere in the middle. It is incorrect to say that, 10 lines from the top.
Yes, yes.
It is incorrect to say that the management purchased the demand draft of someone else. The demand draft was purchased on 6/9/1996. Whereas the order of terminated dismissal was on 4/11/1996. I have to see the records whether the VDA increased to the extent of rupees 134 at the time of the VDA of rupees 134 has been paid to the workman by the management. It is incorrect to say that VDA of rupees 152 is not included in the 1 month wages. They have not included FTA in the 1 month wages. They have not included 3 increments at the rate of 35 in the month wages. But this is the efficiency.
Correct. Whether these 3 increments have to be included, you have to justify now.
Yes, that I mean. Yes. Then, please turn to page 219. Yes. And just read from 220 from the top.
Yes.
It is true, exhibit A13 marked in this proceeding earlier. This copy of the wage register extract.
Where are you reading? It is not true to say that.
220.
220. Yes.
It is true, exhibit A13 marked in this proceeding earlier. The copy of the wage register extract. It is true that exhibit A13 is the extract one paid for the year 1994. It is true as per the entry in exhibit A13, the particulars of the amounts paid and the rates in medical allowance and pension. It is true under exhibit A and B. These items, namely HRA, BDA, and medical allowance, are not mentioned. In the 1 month wage given by us, it covers allowance, PF, LIC, FTA according to exhibit A15. It is true. It is true. It is true in the 1 month wage paid, the HRA is not included. Here it means HRA is not included. Similarly, the medical allowance is also not included. It is not true to say that 134 increase of PDA is not included in this amount. It is not true to say that at the time of dismissal, we have not given 3 increments to the opposite party. But here the first witness says it is not paid. Here, he says, it is incorrect to say that we have not paid. So there is a contradiction.
No, we have to look into the documents and see as to whether they have paid or not.
Yes.
So you have to just substantiate A15.
Yes. A15 is the subsistence allowance payment register. That
they must have records have come on A15. So if A15 indicates the mode of payment or whatever was added to your wages, we have to see whether all this what you have contented in your claim has been added.
This is as far as the evidence is concerned. Then annexure yes is the evidence of the workman on merit of the case.
What is his name? A.C. Ramchandra. A.G. Ramchandra, na Allah.
He is the other man.
And he is, what is it? Ashwath Narayana Reddy.
Ashwath Narayana Reddy, he is the clerk.
Allowance is 274. PF is 27. Rest all is not available. 2000.
The basic plus mentioned as 1955. So that is what the order passed to the tribunal says.
It doesn't indicate anything.
But that was, that particular document was considered by the tribunal.
The 15 does not indicate anything other than 1920.
Then the DMS allowance is 1705.
1705. Then 75.75. 3660.
But that was excluding this PDA, the medical allowance. And then not.
What is this 1705?
That is DMS allowance.
DNS allowance. So what was not included is HRA?
That is HRA, medical allowance, then PDA.
Okay. File antana.
Extreme punishment of
Dismissal. For the charges of
charges of
for the charges
claiming false transportation bill and
yes.
the bill removed for having supplied.
Bill was given.
Yes.
For the plantation seeds which he has purchased, amount of theft alvado.
Claim ಮಾಡಿದಷ್ಟೇ.
Claim andre ತೋರಿಸಿಲ್ಲ, ಅದನ್ನ it is included in his account ಅಲ್ಲ.
But as far as other person is concerned, the charge is that in the capacity of field assistant, he had processed this.
ಸ್ವಲ್ಪ seeds ಹೋಗಿ ಅವ್ರ ಮನೆಯಲ್ಲಿ ಹಾಕೊಂಡಿರ್ಬೇಕು.
ಅವ್ರು ತಗೊಂಡು ಹೋಗಿರೋದು ಅವರ ಜಮೀನು ಹಾಕಕ್ಕೆ ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಇನ್ನೊಬ್ಬರ ಜಮೀನಲ್ಲಿ
ಅದೇ ಇದು ದುಡ್ಡು ತಗೊಂಡು ಅವ್ರಿಗೆ ಮಾರಿದ್ರು ಎಲ್ಲ ಇಲ್ಲೇ ಹಿಂಗೆ ನಡೆಯುತ್ತೆ. This will hear tomorrow. Ask your senior about the proposal for settlement. Saturday for further. Tomorrow we have already 67 mark. Yes. So Saturday for further hearing. Third, the petitioner counsel in part. To hear further. Other rest to petition we will dismiss. 22.2. Yes. So the notes. Yes. Saturday then. Is others who are ready now in this matter? Who are ready?
Blood serial number 51. Blood in connected matter. I am appearing for the respondent number 2 and 3 in the matter. Blood they start for a direction for minimum wages to effect the minimum wages act. Blood.
If you mentioned the other day, right? This matter.
Blood, I am for the
certain petitioners have. Yes, Mr. Gopalaswamy.
Please, my lord.
The other two petitioners have withdrawn their petition.
Yes, my lord.
And what remains is this petition was not maintainable, right?
Yes, please, bro. They are not. They never approach the respondents. They
Without
never
approaching the respondent, without approaching, how is this petition maintainable, Mr. Counsel?
Not in page number 8 in the writ petition in para number 2, they mentioned that they have they have approached the respondent several times. It is absolutely false. no piece of documents have not been produced, and they did not even approach the respondents.
Saturday happens. Saturday.
Lord,
Saturday.
we will place on record, my lord, all those things.
Saturday.
Lord, Saturday I have some inconvenience. Lord. It is
That is the day which is convenient for this court now, because all other matters. Yes, when do you want? Monday.
Monday, please.
Monday.
Please.
Yes.
Please, my lord.
Rest all matters, which date you all want? 29?
Sir, both the matters on Monday, my lord.
Both the matters on Monday,
Both
please.
the matters on Monday.
My lord, kindly direct the
You are
registered
ready?
delete.
Who is your senior? Who is your senior? Where is your file? How do you come to the court without a file, Mr. Consul? I think the other day also this court noticed your, so you should be always ready with the file. Is it the same file or is it some different file?
No, this is the same.
Have you read the papers?
Yes, because
You know what is the contents? What is the petition about?
it is about packages.
Come forward. If you want, you can stand outside the court and also make a submission. We will take your submissions.
The lawsuit is about alleged wrongful termination of employees. Then having claimed
You are the management. Now, what is that order you have challenged?
What we have challenged is an order of the labor tribunal, of labor code.
Termination order has been set aside.
No, it has not been set aside.
Then what has been challenged by you?
The termination order itself and the award of back wages.
Correct. So the order of termination is set aside by the labor court, right?
Yes.
You are the management. When do you want?
This project will be given either next week.
According to you, what is the short date?
Some week.
Yes. Friday, Saturday.
Yes.
21st.
Any other day, Saturday.
That is why we ask you when is a convenient date for you. Friday we don't take up. 24th. Monday happen. Monday. Up to 18 ಎಲ್ಲ Monday happen.
715.
All 2018 matters on Monday. 19, 30, 86, 37. Yes, miss. Tuesday happen. 41. Mr. Natraj. Then 44. When do you want? 30th. 20. Yes, Mr. Shekhar.
Lord, which one?
You are in Kashmir.
Well, Saturday one chance tagoballa madam.
Shekhar, you are surrounded by snow.
Bislu ide madam, bislu ide. Bislu.
Open to sky ಕೂತಿದ್ದೀರಾ?
ಇಲ್ಲ ಅದು ಕಿಟಕಿನಲ್ಲಿ ಹಂಗ್ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
Yes.
ಸೊ ನಂದೆಲ್ಲ ಸಾಟರ್ಡೆ ಒಂದು ಚಾನ್ಸ್ ತಗೊಳ್ಳೋಣ ಅಂತ.
ಆಯ್ತು, ಯಾವ್ದು ಹೇಳಿ?
31, 32. 32.
ಮಂಡೇ ಅದು ಆಯ್ತು.
ಸಾಟರ್ಡೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಲ್ಲ.
ಸ್ಯಾಟರ್ಡೆ ಹಾಕ್ಬಿಡಿ.
ನಂದೆಲ್ಲ ಹಾಕೊಂಡ್ರು ಸಂತೋಷ.
ಎಲ್ಲ ಅವ್ರು ಶೇಖರ್ ಅವ್ರದ್ದು ಸ್ಯಾಟರ್ಡೆ ಹಾಕ್ಬಿಡಿ. 42 also Saturday.
Yes, madam. 42, 46, 48, 50.
ಎಲ್ಲ ಸ್ಯಾಟರ್ಡೆ ಹಾಕ್ಕೊಳ್ಳಿ. ಅವತ್ ಬರ್ಬೇಕು ಮತ್ತೆ ಶೇಖರ್.
ಸ್ವಾಮಿ ದಯವಿಟ್ಟು ಬರ್ತೀನಿ ಸ್ವಾಮಿ. ನಾನೇ ಹಾಕ್ಸ್ಕೊಂಡಿದ್ದೀನಿ.
50 also. ಎಲ್ಲ ಅವ್ರ ಮ್ಯಾಟರ್ಸ್ ಅವತ್ ಹಾಕ್ಕೊಳ್ಳಿ. ಮೇಡಮ್ ಇದಾರಲ್ವಾ ಅವತ್ತು?
ಹೌದು ಸ್ವಾಮಿ ಇದ್ದಾರೆ. 54 also madam.
54 also. NG Fadke? 24. 21 and 22 we will not be taking next week. Okay, we will complete up to 2018. Yes, Mr. Consul, you are waiting for which matter? 57. Just a moment. There's 156 also. 30? 30th. Yes, sir. Your Bala Subramanya.
First case I appear for R3 contesting the
Ah.
The second case I appear for
You are the bank. What is the issue?
under the moral justice clause.
Is there moral turpitude? So if then that is permittable. Yes, that is permissible. Right? Yes,
It's
20.
like, it's like a counter claim. One petition is filed by them. Not the Deputy Chief Legal Commissioner having the clear that. Till the disposal of the criminal case.
Official.
No, that my appeal will be, I can file the appeal after the disposal of the criminal case. It will take 10 years.
So, yes, sir. Where is Venkatesh Dalwai? When do you want? 30th, Monday, Tuesday? Sorry. But this is 22, Alva. We are taking up old matters, right? Yes. 30th. Yes. Serial number 10. Yes.
Serial number 10. Respond, Rao.
No appearance on behalf of the petitioner. As a last chance, list this matter on Monday. On whose behalf you have received? Kamaya. This is Chidananda. You have obtained NOC from Timaya. And so counsel submits that he has filed power for the respondent, registry to verify and proceed. Yes. Give us 42. 30th. Tell us the date for